Sir, coming up, can you tell me your name, please?
Yes, Ryan Mitchell.
All right, you're here in 21 CF 15401. I understand we have an attorney here on this case.
Yes, Your Honor, I'm here on behalf of Amy Mitchell, the victim in this case, Bill McClellan.
Oh, he does? Okay, yes. Mr. Mitchell,
Yes,
you have an attorney in this case.
I have retained the law office of Corey Cohen. They said they would be here this morning.
All right, let me see if they're online.
Welcome to an Econo meeting. You are entering the meeting now.
I'm going to ask my assistant if she's heard from their office. So there's no one on the link. Just give it another minute, see if anyone appears.
Good morning, Judge. This is Rachel Shaw. Is that Mr. Mitchell?
Yes.
Sorry, can you hear me?
Yes, I can.
Excellent. Rachel Shaw for Mr. Mitchell whenever you're ready.
All right, great, counselor. So Mr. Mitchell is here. I've already called the case. Also, we have a witness present
That's Amy Mitchell, Your Honor.
who also has an attorney. All right, so Mr. Mitchell, you're here because a capias was filed, a probable cause order capias was filed, charging you with felony battery, and information has already been filed by the state of Florida. All right, Ms. Shaw, did you wish to be heard on anything in this case?
Yes, Judge. We are just asking for a reasonable bond on this case. As you said, it was an information that was filed. There's also a temporary injunction that's in place with the final hearing set on February 23rd. Mr. Mitchell is able to maintain a separate residence and continue having no contact with the alleged victim in this case. He does run his own business and he is supporting his children as well. So we are just asking for a reasonable bond along with any conditions that the court would like to put in place.
All right, thank you. Ma'am, did you wish to testify today?
Your Honor, she doesn't need to testify. We have no objection to a reasonable bond being set in this matter. There is the temporary injunction in place as well as a dissolution of marriage that's going on. There are supervised visitation right now with the children through an order that was signed by the judge yesterday. So just the standard conditions of no contact, no return to the property would satisfy Ms. Mitchell.
All right, and does the state wish to be heard?
No, Your Honor. I believe defense as well as Ms. Mitchell's counsel are all on the same page, just standard conditions and a reasonable bond.
All right, at this time, Mr. Mitchell, I'm going to set your bond at $5,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
I do, Your Honor.
You can't possess a weapon of any kind, firearm, or ammunition. I will order you maintain a separate residence. Ms. Shaw, does your client need to return to gather belongings, or has that already been taken care of?
Judge, I'm not sure, but if we can add a condition, just a one-time return with law enforcement, just in case he needs it.
All right, I'll do that. So I'll order you can return one time with law enforcement to gather your belongings. You can't coordinate that with the victim, so just talk to your attorney about that.
Thank you.
I'll just also order that you have to comply with the temporary injunction and then any further court orders. So I'm not going to address anything about custody or visitation or children, but you understand that you have a court order in place and you still have to comply with that.
Yes, Your Honor.
All right, are there any other conditions that the state would request?
No, Your Honor.
I do not. Does anyone have the injunction? Oh,
I do.
21 DR 11303-0.
Yes, Your Honor.
Your Honor, I have a copy of it. It was served to me in the court.
Okay, is that the case number?
It is 21 11303.
All right. I just want to make sure that's clear on the record. Okay. Anything else that any party present would like to be heard on with regard to this case?
No, Your Honor.
No, Judge.
State?
No, Your Honor.
All right. Thank you. Good luck, sir. Good luck, ma'am. Thank you, counsel, for appearing.
Thank you, Judge. Have a nice day.
You as well. All right, so we have another attorney here via the link. Counsel, do we know about your client?
Your Honor, I think I'm waiting for your JA to let me know what time my client will be present in the courtroom. And
What's he charged with, or she?
it's a he, and he is charged with 2 counts. It looks like aggravated battery and
What's the is it domestic?
it is not, Your Honor. His last name is Kirby. First name is Stacy.
That might be in the afternoon if it's not domestic.
Okay.
I don't have it on the morning docket. So here's what I can tell you. We have a really, really heavy docket this afternoon. So what I am likely to do is at the end of this court session, ask all the parties involved how long they need to prepare for the next session and then start when they're ready. So do you have a preference on when your client appears?
No, Your Honor, as soon as possible.
Okay, then what I'll do is I'll just ask my JA to contact you as soon as we're done with the morning session and we determine what time we start that session.
Thank you, Your Honor.
Yes, sir.
Have a good morning.
All right, I'll see you soon.
Yes, ma'am.
Okay. All right, that's that one. Oh. Or if you order pretrial with random analysis, so they'll check all of that for you. Sign it. Yes, each person.
You are the only participant.
All right, who do we have next? Are we doing Spanish?
No Spanish. We got one Creole, but
We don't have the Creole yet.
just go straight
All right, so this one is the complicated one. Hostetler. All right, so which case number is he appearing in court today?
Your Honor, he's here in reference to the 2021 MM 6476 AO case, the battery, which was an add-on PTR case yesterday that you revoked.
Yes.
However, this case does not belong to the real defendant, which his name is James Romer. He used the name Christopher Hostetler when he came in. So when he was fingerprinted and it cleared, it came back that that case don't belong to him. So we just wanted to see if you can, what's the meaning? Nunc pro tunc that case, like to come off this defendant
No,
and address the out on bond case. That's his AKA. He used that name, but that's not his real name. It's James Romer. That's his charges is the 2021 CL 15507. We addressed that yesterday.
under the name of Chris Hostetler.
Yes. The 2016 14773 is James Romer's out on bond case. And the 2021 MM 6476 case don't belong to him because she revoked it. So it came back on him, but that's not his case. That case belongs to Hostetler.
But I mean, not on my own motion. I'm not doing that. So are the attorneys doing something with this? We're going to call this at the end of the docket. We're going to give the state and the PD time to look at this because the court is not on my own motion going to do anything with that case.
Well, may I inquire first then, Your Honor?
All right.
So do we have two people? We have one person that was wrongly ordered or perhaps incorrectly ordered yesterday, a Hostetler, and then there's also a Romer, or is it we had Romer yesterday and then, but he was seen as Hostetler. Is that?
I think that's what they're saying. Is I saw Romer, but he told me he was Hostetler.
I see.
So it is a single person, just under two different names, but it is one person.
It's one person.
Okay.
No. But there are charges that belong to two different defendants. There are two different defendants. They're just not both in custody. Right?
Yes. I get what you're understanding.
If it's one person and both names belong to him and all of the cases belong to him,
No,
then there's no reason to do anything.
no, it's two
Right?
different parties involved, but it's one person who used the name of the other person who's not in custody.
Right. So we're gonna
Okay.
have the parties look at that. All right.
Thank you, Your Honor.
Come on up, sir. Mr. McCasler? Nice to see you again, sir. You're here in 21 CF 15502. We spoke yesterday. The state asked for 24 hours. Let me ask the state, did they come up with any additional information?
No, Your Honor, I did reach out to law enforcement and I wasn't able to obtain an additional affidavit. So state's just asking that you find PC for possession of cannabis without the intent to sell or deliver, and state your findings of PC on the other two charges with reasonable bonds.
Any response from the defense?
Your Honor, to my reading of the arrest affidavit, I believe all the cannabis was found in this Louis Vuitton bag that was found in the vehicle, but I don't believe that was in Mr. McCasler's possession.
Your Honor, may
Have you find PC for
Go ahead.
may I respond?
Yes, go ahead.
Law enforcement observed McCasler wearing the same bag prior to entering the vehicle. Prior to the vehicle being stopped and searched.
I observed McCasler walk on South Goldwyn Avenue with the brown Louis Vuitton bag worn on his back. Then remained in the parking lot of the convenience store in the parking lot and entered the store. Both officers observed McCasler wearing the same bag prior to entering the Audi vehicle and leaving the parking lot.
So even if it's not actual possession, when officers find the bags, they would contend that it's at least constructive possession, that he had the ability to exercise dominion and control over and was actually seen in actual possession within a close temporal time frame.
I do think that's enough for probable cause. Of the charge possession of cannabis. Is there a weight, Ms. May?
No, Your Honor, so they would ask for under 20.
All right, Mr. McCasler, at this time, I find there's probable cause that you possessed cannabis less than 20 grams. That's a misdemeanor of the first degree. That you resisted officers without violence and violated state misdemeanors. So at this time, I'll set your bond at $500 on count 1, $100 on counts 2 and 3 each, with special conditions. You can't possess or consume any controlled substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
I'm looking for it, 1 second.
Your Honor, I believe he also qualified for pretrial release. Would you consider straight PTR as opposed to a monetary bond?
Does the state object?
No, Your Honor.
All right, Mr. McCasler, I will place you on pretrial release. The same conditions. Additionally, you'll be subject to random drug screens while you're on pretrial release. Do you understand that?
Yes.
All right. Good luck, sir. Yes, sir. Have a nice day. Good morning. Please tell me your name.
My name is Tyrone Marquise Austin.
All right, Mr. Austin, you're here in 21 CF 135290 because a warrant was issued for your arrest, charging you with aggravated battery on a pregnant person and robbery by sudden snatching. Can I get you to move this because I can't see the witnesses? Sir, while you're in the courtroom, I need you to watch me or this wall, but please don't look at the witness. Thank you. Another judge has already found probable cause. I'll appoint an attorney to represent you. Good morning, ma'am. Do you wish to testify?
Yes.
Please raise your right hand.
Raise your right hand, please.
There you go.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
I'll have the state ask you some questions.
Good morning, ma'am. Can you please state your name for the record?
Miracle Thomas.
And can you please spell your last name?
Thomas.
Thank you. And what is your relationship to Mr. Austin?
He's my boyfriend and also the father of my child.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yeah.
Can you answer out loud, please? Can you answer out loud?
Oh, yes.
Okay, thank you. Do you want to have contact with Mr. Austin while this case is pending?
Yes.
Is there anything else you'd like to tell the court?
Yes. So a lot of this is a misunderstanding. And I did call the day after as far as the robbery thing too. I called the number that was on the packet and they transferred me. No one answered. And I left a message letting them know that nothing was stolen. The purse was in the house, but it had fallen behind the couch. And I called again to follow up. And then also letting them know that I did not want to press charges. I didn't want to pursue. I'm technically due today. And he's supposed to be there for the home birth. Yeah. And I called, and even when the detective reached out to me, I let him know the same exact thing. So I didn't even know this was still going on. Like, we had moved past everything, and like we were preparing to have our baby.
All right, thank you, Ms. Thomas. I appreciate you coming down. I'm concerned because I read the affidavit, even though another judge has already found probable cause, and I was inclined to order that he's not allowed to have any contact with you. However, hearing your testimony here today,
like, he's my only support as far as the home birth. Like, even with my midwives, my doula, like, he's been there for me. Like, I honestly had no idea that this was even still going on because I had reached out on multiple occasions.
but I'm concerned about your safety and the safety of the baby.
Okay.
That's my concern.
I understand that. But he's like, we live in a home together and like nothing has happened since that incident. Like, he's been there, he's been supportive, he's been helping me through the process because I've been borderline like preeclampsia. Like, he's been the main support, to be honest.
All right, let me ask, does the defense have any questions?
Questions, Your Honor?
All right, Ms. May, does the state have anything further?
Yes, Your Honor. I did speak to Ms. Thomas this morning downstairs. She did assure me that she does absolutely want contact and is not afraid of Mr. Austin. In addition, state would just like to point out that this did happen in October, so it has been approximately 2 months. At least according to the affidavit, this was October 10th. I don't believe there's been any other calls to the residents since that time. According to Ms. Thomas's testimony, she doesn't want contact and she is not afraid of him, and they've had no other incidences. State understands the court's concern regarding her safety as well as the baby's safety, and understand that it's within your discretion. However, state has no objection to a no hostile due to the conversation I had with Ms. Thomas this morning.
I also show that he has no criminal history.
Yes, Your Honor, I believe it was expunged.
All right. Mr. Austin, here's what I'm going to order. Your bond is $5,000 on count 1, $1,000 on count 2. I'm going to allow you to have peaceful contact only with the victim. Do you understand what that means?
Yes, ma'am.
No hostile contact.
Yes, ma'am.
No shoving, no pushing, no spitting.
Yes, ma'am.
Don't even raise your voice.
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition.
No, ma'am.
All right. Good luck, sir. Thank you, ma'am, for coming. I really do wish you the best of luck. Please tell me your name.
Matthew Cummings.
You're here in 21 CF 15565, charged with tampering with a witness and battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Good morning, ma'am. Do you wish to testify?
Yes, I do.
Please raise your right hand to be sworn.
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
I'm going to let the state ask you some questions.
Good morning, ma'am. Can you please state your name for the record?
Kimberly Clark.
And what is your relationship to Mr. Cummings?
He's my significant other, my boyfriend.
Are you afraid of him?
No.
Has anything like this ever happened before?
Yes, ma'am.
Approximately how long ago would you say the last time was?
November 12th.
Do you want to have contact with him while this case is pending?
Yes, please.
All right. Is there anything else you'd like to tell the court?
I would like to ask for him to be able to come home. I am not afraid of him. I would like him to be home and peaceful. I maybe misrepresented the truth to the police.
Your Honor, state does have a pretrial detention motion.
Oh,
What does that mean?
you filed? Are you filing it now?
Filing now, Your
All right.
Honor. It was just drafted this morning.
Thank you. Let me ask, any questions from the defense for
No
this
questions.
witness?
No questions at this time, Your Honor.
All right, thank you. All right, thank you, ma'am. You can stay right there while we finish the case.
Thank you so much, Miss Gibson. Judge Gibson. I'm sorry if I
It's okay, it's okay.
misrepresent your name.
No, that is also my name.
I
okay.
apologize.
All right, Miss May?
Yes, Your Honor. I understand victim's testimony here today. However, state does have significant concerns regarding her safety as well as the community safety. State filed this motion largely based on the defendant's 2 prior arrests and the proximity to this one. There was an incident on 9/30 as well as an incident on 11/12, and then the current incident that he's here for today that happened on 12/7. State can file a pretrial detention motion to have the defendant held no bond until that hearing downtown in approximately 5 days.
That was my mistake.
Ma'am, I need to ask you not to interrupt.
Oh, I apologize. I'm so sorry.
I can give you another opportunity to speak, but I need to hear the arguments from the attorneys.
Yes, ma'am.
Thank you.
Some of the reasons the court can find an order that the defendant be held pretrial is the intent to obstruct the judicial process, has threatened or intimidated or injured the victim, a potential witness, juror, or judicial officer, or conspired to do so, as well as a threat to the community, and that is a dangerous crime. Under 907-041, that DV is a dangerous crime under Florida statutes. State contends that he is a threat to both the community, and that within the affidavit, it does state his calls to law enforcement, basically threatening law enforcement, saying he knows the mayor, and other things along those lines, as well as previously saying that the victim cannot go to Harbor House due to his mother having connections there. So he's a threat to both the victim as well as the community. Through both of those ways, he's shown the intent to obstruct the judicial process, as he's charged with tampering with the witness today, as well as charged with, I believe, tampering before in one of the other previous cases. It is within the affidavit that the victim on scene stated that she's too afraid to move forward with charges due to the fear of retaliation. The defendant has repeatedly told her he would have her Baker acted, and she is terrified of that happening. He threatens to Baker act her and tells her if she calls 911 to make sure that she was arrested because he and his mother know people at the sheriff's office. There's been repeated threats in regards to Harbor House and knowing someone there, so she would not be safe there, as well as the sheriff's office, as well as being friends with Mayor Demings. State has serious concerns given the temporal time between all these incidences, as well as the threats that have been made, as well as the charges within each of the cases. I do believe that 2 prior cases were dropped, and there's an explanation given to law enforcement within this affidavit on why those were dropped. So this time, state is concerned for both the victim's safety as well as the community safety, and believes he will continue to obstruct the judicial process and threaten or intimidate the victim while this case is pending.
All right, thank you. Any response from the defense?
Your Honor, in the previous 2 cases, in 930 and 1112, was there a no contact order to Mr. Cummings with this victim?
There was a no contact order. Defense got it changed to a no hostile.
And then did he violate that no contact order in each time during its duration?
I'm sorry?
Did he violate that order during its duration?
No, I believe it was no prost or declined to prosecute.
So 21 MM 233 was null prost before November 12th, 2021.
233 was dismissed 11/9/21.
What do you mean was dismissed?
Declined to prosecute, Your Honor.
The state. On what date?
11/9/2021.
All right, 3 days before November 12th. All right, go ahead, Mr. Rance. Any other?
My argument would be that this pretrial detention motion argues that there's no reasonable protections. But I believe if this court ordered a no contact order, I believe that would be sufficient without holding Mr. Cummings at no bond, or excuse me, detaining him pretrial. May I have a moment to confer, Your Honor?
Yes. Ms. May, in your motion, sub C or C sub 1, are you suggesting sub 1 exists or not? The defendant has previously violated conditions of release?
No, Your Honor. It's just one of the reasons why the court can't hold him.
I see. Okay, no problem. All right, Counselor, I pulled up the rule 3.132. It says, the state may file with the judicial officer at first appearance a motion seeking pretrial detention signed by the state attorney or an assistant, setting forth with particularity the grounds and the essential facts on which pretrial detention is sought, and certifying that the state attorney has received testimony under oath supporting the grounds and the essential facts alleged in the motion. Where's the testimony under oath?
Your Honor, I believe sub 4, with the 3 crimes would particularly be the grounds that were under oath as they were able to be judicially recognized, the different dates of cases that the defendant had, as well as the affidavit that we have before today is under oath.
The affidavits.
Yes, Your Honor.
All right.
Which I can provide to the court if you would like the other 2 cases. And Your Honor, my reading of the rule, the 3.132, is if it's otherwise facially sufficient and there is probable cause, then they may be detained for the 5 days for there to be a hearing downtown.
That is what the rule says. I'm reading it right now. If the motion for pretrial detention is facially sufficient, the judicial officer shall proceed to determine whether there is probable cause that the person committed the offense. I've already made that determination here this morning. If probable cause is found, the person may be detained in custody pending a final hearing on pretrial detention.
Your Honor, if I
Yes, sir.
reassert my argument that Mr. Cummings never violated a no contact order, he was able to have contact. So as to that evidence that he has intent to violate or obstruct a judicial order or process, I believe that would make the facts insufficient in this motion. I'll have you deny it, but as the rule states, if you do find that the motion is sufficient, he is entitled to a final hearing on this within 5 days, I believe.
I think the motion is facially sufficient because if you read sub 2, the defendant with the intent to obstruct the judicial process has threatened, intimidated, or injured any victim, potential witness, juror, or judicial officer, or has attempted or conspired to do so, and that no condition of release will reasonably prevent the obstruction of the judicial process. That's contained within this probable cause affidavit.
And you're using the testimony of the arrest affidavits in the previous cases as a foundation for that?
In the instant case, the probable cause affidavit states that your client threatened the victim in this case, he threatened law enforcement in this case. And it says, the defendant with the intent to obstruct the judicial process has threatened, intimidated, or injured. And in this affidavit, we have not only threats, but also injury to the victim.
Just making it clear for the record, Your Honor.
I understand. I appreciate that. I think it is facially sufficient, Counselor. So at this time, I'm going to grant the state's motion for pretrial detention. Mr. Cummings, you're going to need to stay in touch with your attorney because at this time you'll be held without bond. However, even while in custody, I want to be sure you understand that I am ordering you can have no contact with the victim. Do you understand what no contact means?
Yes, Your Honor.
All right, Ms. May, do you have an order?
I do not, Your Honor. I'll draft one right now.
All right. Ma'am, I understand your testimony this morning. However, the state filed a motion for pretrial detention. I granted that motion. At this time, he will not be released, and he cannot have any contact with you while he's in custody. So if you have questions, you'll want to call his attorney and maybe the state attorney's office.
I've already called the state attorney and asked them to drop everything, and they stated that they would not. I've been trying to already have this dismissed.
So this is the state of Florida versus Matthew Cummings. It's up to the state of Florida whether they choose to prosecute this case or not. It's not up to you. That's why. Good luck, ma'am. Thank you for coming. All right, good luck, Mr. Cummings. Ms. May, is this your filing or are you going to?
What do I do now? He doesn't get to leave jail?
He does not. You can leave, he cannot. So he'll have another hearing in front of the trial judge downtown.
And I go there?
Yes, you have a right to be at that hearing and to testify.
When is that? And how do I get that information? And am I allowed to have contact with his mother?
You can have contact with anyone. The court doesn't have jurisdiction over you. I only have jurisdiction over him. So he can't have contact with you, but I'm not ordering you to do anything.
But he's my medical surrogate, and I have a doctor's appointment that I need him to be there with me.
He cannot right now, ma'am.
So if I die, then my parents will sue the state of Florida?
I don't know what your parents will do, ma'am.
Well, it's gonna happen because I need a medical surrogate. I have breast cancer. I have other shit going on.
Ma'am, please watch your language. This is a court proceeding.
Well, I understand, but you're not granting me what my civil rights are and what his civil rights are.
So that's not actually accurate.
You've made choices that are out of your jurisdiction, and I will contact Bernie McCabe.
All right, good luck, ma'am.
Peace out.
Your Honor, is he still entitled to a final hearing on this?
He is. That's in the rule. Ms. May,
I believe it's within 5 days, and yes, Your Honor, it is.
this is your filing?
Yes, Your Honor.
You didn't sign it.
Did I give you one of the unsigned?
Yes.
I think I did.
So I don't think this is your final one.
What I did. And the signed. I'll switch. You're signed.
Yes. Yes. Okay, thank you.
Sorry, I got lost in the jumble of papers.
This morning? I have not. And his attorney didn't tell me anything about being in trial. I asked him if he had a preference, and he said, no, I gave him the opportunity. He said nothing about that, so I'm not sure if his client knows his schedule. Please tell me your name.
Dazir.
Mr. Dazir, you're here in 21 CF 15230 because a warrant was issued for your arrest, charging you with burglary of a dwelling with assault or battery, domestic violence. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Yes, Your Honor, given that it is a F1 that is punishable by life, state's asking that you hold a no bond pending an Arthur hearing.
Any response from the defense?
Yes, Your Honor. We've changed our strategy a bit on these kinds of cases, and we would have you find proof evident presumption grade before holding Mr. Dazir no bond. He is entitled to that finding under our state constitution, the statute, and the rule of criminal procedure 3.131.
Respectfully, Your Honor, that's not completely accurate. There's a split in the DCAs about whether, not the 50 state, I believe is the third and the fourth, regarding if proof evident presumption grade needs to be found to find, to hold someone no bond pending an Arthur hearing. According to Thornton versus Junior, which is a third DCA case, 275 Southern 3rd 726, you do not have to find proof evident presumption grade to hold him no bond pending an Arthur hearing at a later time if it is a punishable by life offense.
Right, that is my understanding of the state of the law right now, Mr. Brantz.
Yes, Your Honor.
So I'll just ask if you've had a conversation with your client and explain to him your position, your office's position is he's entitled to basically 2 Arthur hearings, but there's a split in the DCAs. So what that means is if I find proof evident presumption great, and then you go downtown to see the trial judge can say, you've already had your Arthur hearing, we are not doing another one, and your client will stay in custody with no bond. I just want to give you a moment to discuss that with him before you ask me to make that determination here today.
Yes, Your Honor, but just to reiterate, we've discussed in our office the difference between the finding and the Arthur hearing, because an Arthur hearing is a full evidentiary hearing, which we don't have today, but the finding in our interpretation of the Constitution, the statute, the rule, and the court's, the split in case law is that these are two separate actions. There's a finding of proof evident presumption grade to hold them no bond, and then they are then guaranteed an Arthur hearing in front of the trial judge to have a full evidentiary hearing to set bond.
Right. I understand that's your office's position, but I want to make sure your client understands because he's the person that potentially can be held at no bond indefinitely until his trial date because of your office's position.
Yes, Your Honor, thank you.
Okay. Can I ask corrections? Each time you bring someone in, can you just ask them to say their name? I'm really hoarse and we have 100 people today, so.
After discussing with my client, Your Honor, just a moment. After speaking with Mr. Dazir, Your Honor, just a moment.
Yes. Thank you.
Your Honor, may we be
Yes.
heard?
Yes, yes, yes.
After speaking with Mr. Dazir, I believe he does wish the court to find proof evident presumption great based on the facts in the arrest warrant. That is the state's burden to show that there is proof evident presumption great, which Thermidor v. State suggests is a burden higher than reasonable doubt. But just as a argument prior to that determination, the facts in the arrest warrant suggest that the alleged burglary and battery occurred simultaneously. In my mind, it would be a burglary then followed by an assault or battery or an intent for assault and battery. But the two occurring together may lower the finding to below a reasonable doubt. It may not make it past the jury, but that would be my only argument in the facts of the warrant. Further, under the Constitution, the statute, and the rule of criminal procedure, regardless of the case law split, I still believe Mr. Dazir does have a right to a full evidentiary Arthur hearing in front of the trial judge.
All right, counsel, do you want to state the provisions of each of these things to which you're referring?
Yes, Your Honor. Under the Florida Constitution, Article 1, Section 14, unless charged with a capital offense or an offense punishable by life imprisonment and the proof of guilt is evident or the presumption is great, every person charged with a crime or violation of municipal or county ordinance shall be entitled to pretrial release on reasonable conditions. If no conditions of release can reasonably protect the community from risk of physical harm to persons, assure the presence of the accused at trial, or assure the integrity of the judicial process, the accused may be detained. That is repeated in the Florida Rule of Criminal Procedure 3.131. Is also further emphasized in Florida Statute 907.041, which subsection 2 suggests that the rules of procedure for pretrial release determination shall be governed by the rules adopted by the Supreme Court, the aforementioned Rule of Criminal Procedure 3.131. And then if our client is to be held no bond, according to Rule 3.132, as we discussed in a previous case, the pretrial detention motion must be filed.
All right, any response from the state?
Yes, Your Honor. In response to just you finding proof of presumption great, or in response to counsel's reading of the law?
All of those things.
In response to counsel's reading of the law, state would still contend that under Thornton v. Jr., a third DCA case, it held that the court can hold the defendant without finding proof of evident presumption great if charged with a PBL or capital offense. It further goes to state that the silence of the section of the Florida Constitution, Article 1, Section 14, concerning the right of pretrial release regarding the timing of the required hearing means that other bond hearing must be held within a reasonable time. And at IA could be a reasonable time, or at a later time could be a reasonable time as well. In regards to the actual finding of proof of evident presumption great, in the instant case, the defendant allegedly rang the victim's doorbell. She opened the door slightly, held her body weight and her foot holding the door closed, to which the defendant pushed the door and forced his way into the residence. Since she was using her foot and her body weight to attempt him to stop from opening the door, he was able to overpower her and the door struck her. It is stated that he does not have any rights to the apartment or any other legal ways of entry. For a burg structure with a battery therein, State just has to prove that he entered a structure owned or in the possession of the victim. And while entering that, he committed a battery, which is a unlawful touching against a victim's person. State would contend that both happened in this case. And the victim's intent for the defendant not to enter her residence was fairly clear by holding the door with her foot and her body weight before she was overpowered. Counsel made an argument regarding that it happened simultaneously. I don't believe there's anything within the statute nor the jury instruction that says it cannot happen that way. So given the facts alleged within this warrant, as well as the jury instruction, what the state would have to prove for this offense, state would argue that there is PC and also prove evident presumption great that the defendant did enter her residence and commit a battery upon doing so.
All right, thank you.
And Your Honor, just as an aside, if you do find proof evident presumption great, that just indicates that Mr. Dazir does not have a right to pretrial release. You can still set a bond in this case.
Yes, that is also true. Thank you, Counselor.
Your Honor, state would also like to bring your attention that it does appear that he is also out on bond for a bat DV. And the victim is the same victim.
I'm sorry, what?
So the state would just like to also bring your attention that he's also out on bond for a bad TV, and the victim is the same victim as alleged in this case.
All right, so I pulled up the statute and the rules so I could review them as you were arguing. For the offense of burglary, burglary means entering or remaining in a dwelling, a structure, or a conveyance with the intent to commit an offense therein, unless the premises are open to the public, which is a private residence is not. So in the affidavit for this warrant, I've reviewed the affidavit. The allegations are that the defendant went to the victim's residence where he has no lawful right to be, that is not open to the public, rang the doorbell, and when she opened the door, he forced his way into the private residence. That would be entered or remained in a dwelling. And the affidavit further states that because she was holding the door closed to stop him from entering, when he forced the door open, he struck her with the door. A battery is an intentional touching against someone's will. So according to the statute, 810.02, burglary is a felony of the first degree unless in the course of committing the offense, the offender makes an assault or battery upon any person. The affidavit is clear that when the defendant forced the door open, he struck her with the door. That's a battery.
Yes, Your Honor. But my legal argument, I suppose, and again, this may be going to the point that a jury might not find beyond a reasonable doubt, is that with a burglary with the intent to commit an offense therein, and then a burglary with an assault or battery would be two separate instances, the burglary and then the offense here being a battery or assault, with those occurring simultaneously with, according to the warrant, the entry as well as the injury was their intent to burgle and then commit a battery or assault. So because they're occurring simultaneously, the question of intent may be one for the jury.
But Counselor, the statute says in 810.02 sub 2, burglary is a felony of the first degree if in the course of committing the offense, the offender makes an assault or battery upon any person. It says in the course of committing the offense.
I understand, Your Honor.
I think a plain reading of that statute is during the burglary, if someone makes an assault or battery, that's a burglary with a battery.
I understand, Your Honor, but again, the question of intent is one for the jury, and proof evident presumption great is one beyond a reasonable doubt, which is one that a jury is supposed to find as well. And I have a question on intent. This court may not, but again, if reasonable minds differ, then perhaps there is some doubt in that series of facts.
Your Honor, respectfully, counsel's argument that a jury may not find beyond a reasonable doubt is purely speculative, as we are nowhere close to that at this point. For an Arthur hearing or for finding a proof of presumption great, Your Honor is a sole fact finder. So if Your Honor finds that there is intent, that is all that is sufficient for this court, as wondering what a jury would do would be purely speculative for a lower standard.
Yeah, unfortunately, Mr. Brantz, what a jury may or may not do isn't the question here, because you've put the court in the position of being the fact finder today. So it's up to the court to determine, as you said, beyond a reasonable doubt, up to proof evident presumption great. I understand the burden of proof is different But within the four corners of this affidavit, it is clear to the court that your client intended to break into a home to which he was not legally entitled to be. And it is also clear that the defendant knew the victim was holding the door with her body, and he intended to push her out of the way. That's a battery. As you are aware, a battery in the state of Florida is an intentional touching against someone's will. It does not have to be a punch. It does not have to be with a weapon. There does not have to be any great bodily harm.
Your Honor, if I may, the defense doesn't have the burden to show that there isn't proof evident presumption grade. I believe the burden is on the state to show that there is proof evident presumption grade. I'm simply arguing that, making a legal argument as to reason or proof evident presumption grade, which is a standard beyond that of reasonable doubt. My question of intent is one that would plant the seed of reasonable doubt in the fact finder's mind, in this case, the court.
I understand. I don't think the defense has any burden here today. But I think in the four corners of the affidavit, your client's intent is clear to this fact finder. At the time he was forcing his way into a residence by pushing the door forcefully, he knew there was a person on the other side of the door. He intended to push that person out of the way and enter the residence, which he had no lawful right to enter.
Ma'am?
Sir, you can say anything you want, but you're not required to say anything today. Do you understand that?
I believe we'd like to remain silent on that, Your Honor.
All right. Mr. Dazir, I want to make sure you understand, you have the right to say anything you wish, but you're not required to say anything, and everything you say is being recorded and can be used against you later. I'm sure that's what your attorney said to you, but I just wanted to make sure you understand that.
He understands, Your Honor.
I do find proof evident presumption grade exists in this affidavit, counselor. Now, you are correct. Earlier you said, even if I find that, it is within the court's discretion to set a bond.
Yes, Your Honor.
However, what was the bond date in the battery dating violence? 21 MM 8127.
1 second, Your Honor.
I don't have that date anywhere.
It was November 21st.
Thank you. 2021?
Yes.
Thank you. Sorry, I just want to make sure I'm accurate.
Your Honor, if I may, if you're considering setting bond even after finding proof evident presumption grade. In the 21 MM 8127 case, date of alleged incident on that was 11/16/2021. It is alleged in that case that law enforcement responded to an anonymous call of a woman yelling, "Help me," which was coming from the defendant's residence. When law enforcement arrived, I'm sorry, I was incorrect. The defendant arrived at the victim's residence and texted the victim to open the door. The victim texted the defendant to remind him of the no contact order and to leave her alone. Later, when the victim left her apartment, the defendant approached her, placed her in a chokehold, but did not impede her breathing. The defendant then sent a text message apologizing for choking the victim and requested the victim not to contact police. There was a prior BAT DV out of Brevard that was a withhold from 3/3/21, and it is the same victim as this instant case.
Was that Broward or Brevard? I have Broward.
I have Brevard, but I can double check. So, Your Honor, it seems to be, it was recent in temporal time. This allegedly occurred middle of November. It is now early December. It is the same victim. It was another issue regarding the defendant arriving at the victim's residence and texting her to open the door, victim not wanting to open the door. So later when she leaves, he approaches her and puts her in a chokehold.
You said the victim texted and reminded him of the no contact. What no contact? Is there a no contact order? Is it from the Brevard case, or is there an injunction?
Yeah, that is per my reading of the warrant from that case. The defendant texted again, just open the door, I'm gonna talk to you. The victim responded that there's a no contact order in place and that you still put your hands on me, and that she had a headache. I don't have access to Brevard or Broward's actual case file. However, the victim must have thought there was a no contact order. I'm not sure if that was from that case or from an injunction. However, she did inform the defendant that she believed that one was in place, and that he should not be contacting her.
Because of that pending battery case for which your client is out on bond, I'm not inclined to set bond on this case. He's not entitled to it, but I might have considered it, except that he's out on bond for battering the same victim. So, Mr. Dazir, when you're out on bond in a criminal case and you're arrested for committing a new criminal case, you can be held at no bond. Your bond can be revoked and you held at no bond. At this time, I'm going to do that. I'm revoking your bond. I'm holding you at no bond. In the instant case, you'll also have no bond. However, even while in custody, you can have no contact with the victim. Do you understand what no contact means?
Yes, but I ain't never talked to the girl.
All right, then it should be easy to have no contact with her now. Stay in touch with your attorney, sir. They'll likely want to file a motion in front of the trial judge soon. Yeah, because he can't get out.
And again, for the record, Your Honor, may I be heard on the two, may I be heard?
Yes.
I still feel that these are two separate functions, the finding of proof, evident, presumption, great, and his right to an Arthur hearing under the Arthur v. State. The judge may disagree with me, but that would still be our position.
I understand. It'll be up to the judge downtown now, whether they'll grant that or not.
Yes, Your Honor.
All right, good luck, sir.
Lee Grimes.
Sir, you're here in two cases, 21 CF 11971. A capias was issued for your arrest for failing to appear on a charge of burglary of a dwelling. There's no bond authorized. I'll appoint an attorney to represent you. In 21 CF 15566, you're here charged with aggravated battery on a pregnant person, burglary of an occupied dwelling, robbery by sudden snatching, aggravated assault upon a pregnant person. There is probable cause. I'll appoint an attorney to represent you in this case as well. Does either attorney wish to be heard on bond?
Your Honor, state would just ask for a reasonable bond to be set. He's otherwise entitled to it. The allegations within the affidavit are particularly troubling. And it appears that the victim is approximately 9 months pregnant with the defendant's child. The state would just ask for a reasonable bond, taking all that into account and taking into account the allegations that are within this affidavit.
Anything from the defense, Mr. Brantz?
Yeah, we would argue for a reasonable bond as well, Your Honor. There have been no convictions here in Florida or out of state. There have been some arrests, however, but I would still have you set a reasonable bond in this case.
Mr. Grimes, at this time, your bond on count 1 is $5,000. Your bond on count 2 is $10,000. Count 3 is $5,000. Count 4 is $5,000. With special conditions, you can have no contact with any victim or witness in this case. Do you understand what no contact means?
Yes, ma'am. I have a question, though. Can I ask you?
You can ask anything you wish, but everything you say is being recorded and can be used against you. Do you understand that?
Yeah. The question is because before this incident, I went to the hospital because my son was supposed to be born. So if my son is born, can I still go to the hospital? Or
No.
All right.
You can have no contact with her at this time. You can't possess any weapons, firearms, or ammunition. Were you two living together?
Yeah, we was at one point.
All right, you cannot now. Oh, it says you're not, so you don't have a reason to go back to her residence for any reason. I'm going to say that you can't go back there. You can't be within 1,000 feet of the victim's residence or place of employment. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir.
It was no bond on the FTA, correct?
Right.
Andres Hobson, ma'am.
Good morning. You're here in 21 CF 15567 because a warrant was issued for your arrest, charging you with domestic battery by strangulation, false imprisonment, and battery. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $5,000 on count 1, $10,000 on count 2, and $500 on count 3. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Good luck, sir.
Asia Riley.
Good morning. You're here in 21 CF 15568, charged with aggravated battery, criminal mischief, damage greater than $1,000, and battery domestic violence. There is probable cause. I'll appoint an attorney to represent you.
Your Honor.
Yes.
As to the 2 charges of battery, would the agbat be the Lysol spray can? Would that be the,
That's how I read the affidavit, yes.
and would those be 2 separate instances, to be charged as 2 separate crimes, the battery and then the aggravated battery, or would it be 1 charge of aggravated battery?
I read the affidavit as there are 2 separate charges. The battery with the Lysol can is separate from the battery with her hands.
You didn't see it as 1 series of events?
No, what says the state?
Well, Your Honor, state would contend that state can file, at least at this stage in the proceedings, can file cases as with lesser included. However, state would contend that there are 2 separate instances. One of the defendant grabbing her wig, causing her to fall to the ground, getting on top of her and punching her in the face. She was then able to get up and walk away. And while she's trying to walk out of the apartment, the second battery occurs. So it's not 1 string of events. Seems like it was 1 initial fight. And then she was trying to walk away and get away from the situation when the second battery occurred.
That's why I found probable cause for both charges. There is a break in the incidents. All right, ma'am, your bond is $5,000 on count 1. $500 on count 2, $100 on count 3 with special conditions. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Good luck, ma'am.
Your Honor, this one, I believe the case number may be wrong. I believe it's 15361. I currently have it as 15251.
I have it as 15361.
They may have changed it on the affidavit. I just wanted to make sure that the record was clear.
Councilor Swift.
Good morning, sir. You're here in 21 CF 15361, charged with battery with a prior battery, domestic violence. A probable cause order was issued, and then the state filed an information charging you with that. At this time, I'll appoint an attorney to represent you.
You have to say.
Excuse me, can I ask a question?
Sir, you can ask anything you wish. Everything you say is being recorded and can be used against you.
Your Honor, may we have a reading of the facts in the affidavit? Or may we request?
I don't know that I have the affidavit. There's an information filed.
Your Honor, I have the factual basis.
All right, go ahead.
On or about 6/12/21, the victim was in the corner store when the defendant came in and punched him on the side of the face. The store employee pulled the defendant out of the store, and the defendant left on foot. The alleged victim is Eugene Smith. And also
Information charges Eugene
prior-
Swift.
I'm sorry?
The information says Eugene Swift.
Yes, Your Honor.
I'm sorry, I thought you said Smith.
No, I'm sorry if that came out unclear. Eugene Swift.
Hard to hear in here.
And the prior conviction was from 19 MM 613.
On the 8th day of November, 2019. At this time, sir, your bond is $5,000 with special conditions. You can have no contact with the victim. You can't possess any weapons, firearms, or ammunition. You can't return to the scene for any reason. Do you understand? All right, good luck, sir. Mr. Brands, just for your information, a lot of times when there's a probable cause order and an information filed, I don't have access to the affidavit.
Understood, Your Honor.
So-
I apologize.
No, it's okay. I just wanted you to know that's why I don't even have it. But she did, so it worked out.
Thank you, Your Honor.
David Ackley.
Mr. Ackley, you're here in 21 MM 8649, charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess any weapons, firearms, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck, sir.
I have first the clerk.
Yes.
Jacob Foster.
Good morning. You're here in 21 MM 8381. Sir, I need you to look at me or this wall while you're in the courtroom. Please don't look at the witness. You're charged with stalking domestic violence. A warrant was issued for your arrest, so another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Good morning. Do you wish to testify?
Yes, ma'am.
All right, please raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
State.
Good morning, ma'am. Can you please state your name for the record?
Sabrina Heimbach,
And can you please spell your last name?
Heimbach.
And what is your relationship to Mr. Foster?
He is my ex-boyfriend.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
Do you want to have contact with him while this case is pending?
Yes, ma'am.
Is there anything else you'd like to tell the court?
Yes. Can I go ahead? I just wanted to say I never wanted to press charges or anything, and I would ask for peaceful contact because we do work together.
Where do you work, ma'am?
It's called No Sweat AC and Heating.
All right, any questions from the defense?
No questions, Your Honor.
All right, thank you.
Your Honors, they would bring your attention to the last, looks like full paragraph. This begins with while speaking.
All right, so what says the state as to bond conditions?
Your Honor, given the allegations within the affidavit, it said, it alleges that since early November, Mr. Foster has been constantly calling, sending text messages, creating fake social media accounts, showing up, threatening to show up to her apartment. The victim has repeatedly told him to stop. It's also alleged that the defendant will come by her office and just stare at her without saying a word. However, they do allegedly work at the same office. However, I believe he is in the field and she is in the office. It alleges that she's extremely distressed as he continues to speak to her and contact her, even though she's done everything she can do to get him to stop. So at this time, state would ask for a no contact, Your Honor, which can be changed at a later time.
Can I say one thing?
Just a moment, ma'am. Are you done, Ms. May?
Yes, Your Honor.
All right, yes, ma'am, go ahead.
Like I said, I never wanted this to happen, and I've honestly had a change of heart, and I wish to have contact with him, especially because we work together.
So, ma'am, in the affidavit for this warrant, it says that you told the law enforcement officer you were in fear that Foster will escalate his actions.
That's not true.
So that's what's concerning to the court. It also says that you reported you're extremely distressed and that you've done everything you can think to get him to stop, and he won't stop.
He has stopped contacting me since maybe like a week and a half ago. But I never told the officer I was scared of him. I've never been scared of him ever.
All right, anything from the defense, Mr. Brantz?
Just to set a reasonable bond on this case, Your Honor. He has a very limited, if any, criminal history. He has ties to the community. His mother was contacted through pretrial services. That's all.
His mother's what?
His
Was
mother
contacted?
Was contacted through pretrial services.
Okay, I'm sorry, I didn't hear that.
I'm sorry.
It's okay, I'm having trouble today with the masks and the
And I
courtroom.
tend to mumble, so that doesn't help either. I apologize.
It's okay. I just want to make sure I understand it.
Your
All
Honor.
right, I'm sorry, what?
Sorry, I do believe there was a order setting hearing for an injunction and a petition filed. However, I don't see that there ever was a temporary injunction or anything placed. The petition was filed 11/30 with Ms. Heimbach as the petitioner and Mr. Foster as the respondent.
You filed a petition for an injunction?
Yeah, I'm going to file a motion to dismiss it because I still want to have contact with Jacob Foster.
All right, well, you're not going to be able to at this time. Mr. Foster, I'm going to set your bond at $500 based on the fact that you have no criminal history and the testimony here today. However, I am going to order that you can have no contact with the victim at this time. Do you understand what no contact means? You also can't possess any weapons, firearms, or ammunition. Because you work in the same place, I'm not going to order any, 500 feet distance or anything like that. But I'll just remind you that I've ordered that you can't have any contact with her. So you need to talk to your attorney about how to make that work while you're at work. Yes. All right, good luck, sir. Thank you, ma'am. Good luck.
Thank you.
McCasler.
Good morning. You're here in 21 MM 8645, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means? You can't possess any weapons, firearms, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck, sir.
Please, Green.
Good morning, ma'am. You're here in 21 MM 8652, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess any weapons, firearms, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, and you must comply with any plan set in place by DCF. Good luck, ma'am.
Andrea McFadden.
21 MM 8644. Good morning, ma'am. You're here charged with battery domestic violence. There is probable cause. At this time, I'll appoint an attorney to represent you. Good morning. Did you wish to testify?
Yes, sir. Yes, ma'am. I'm sorry.
That's all right. Please raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
State.
Good morning, sir. Can you please state your name for the record?
Jacquez Davis.
And can you please spell your last name?
Eavis.
Thank you. And what is your relationship to Miss McFadden?
My girlfriend.
Are you afraid of her?
No, ma'am.
Has anything like this ever happened before?
Ma'am.
Do you want to have contact with her while this case is pending?
Yes, ma'am.
Is there anything else you'd like to tell the court?
Yes.
Good.
I'm having a little trouble hearing you. Just make sure you get close to the mic. Thank you.
I'm sorry, miss. I just wanted, I didn't want anything to happen. I don't want no charges to be filed. I guess the police had a misunderstanding because it didn't happen the way it happened. We just had an argument. It was nothing that needed to be filed. I just didn't want anything else to happen. I'm sorry, miss.
All right. Thank you. Mr. Brantz, any questions from the defense?
No questions, Your Honor.
Any bond requests, Mr. Brantz?
With witness testimony here today, and as Ms. McFadden does otherwise qualify for pretrial release, I would just have you set straight PTR. But if you are uninclined to do so, coupled with her little, if any, criminal history, I would have you set straight PTR. If not, just a straight bond.
Your Honor.
I believe the statute requires that I set a monetary bond with PTR because it's a domestic battery case.
Then I would have you just set straight bond, Your Honor.
I will reduce the amount significantly if I place her on pretrial release. She doesn't want that?
Let me inquire, Your Honor.
All right.
I believe she would request the low monetary bond with pretrial release.
All right, at this time, ma'am, I'll place you on pretrial release and require that you post a monetary bond. However, I'll reduce that amount significantly to $100. Based on the testimony here today, I will allow you to have peaceful contact with the victim. Do you understand what peaceful contact means?
Yes, ma'am.
No hostile contact, no yelling, no shoving, no pushing. You can't possess any weapons, firearms, or ammunition. Good luck, ma'am. Thank you, sir. Good luck.
Thank you, miss.
Natasha Kanye.
Good morning. You're here in 21 MM 8612, charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means? You have to answer out loud. Yes. You can't possess any weapons, firearms, or ammunition. Were you two living together? All right. I'll order no return to his residence. Any other conditions the state would request?
No, Your Honor.
All right, good luck.
State with no contact with the witnesses, Your Honor. I believe there were two independent witnesses.
I will order no contact with the witnesses as well. All right, good luck, ma'am.
Michael London.
Good morning. What's your name?
Michael London.
20 CF 541. Mr. London, you're here because a warrant was issued for your arrest out of Flagler County for violating probation Hold on one moment. There's no bond authorized on the, oh, wait. This is a different warrant. There's no bond authorized on this warrant. I'll appoint an attorney to represent you, and we'll notify them that you're here so they can transport you. Good luck.
Stephen Thomas is no help.
OR 780009. It's an out-of-county warrant, Mr. Brantz. I'm going to appoint your office.
We'll waive the appearance, Your Honor.
All right, there's no bond.
And then did you have Vitor?
I'm sorry?
Vitor Dielencar?
Ismail Del Valle.
Good morning, sir. You're here in 18 CF 11666, charged with violating your probation. I'm going to appoint an attorney to represent you. There's no bond on this charge. My computer is moving slowly. The allegation is you failed to make court cost payments, failed to complete or remain in mental health treatment, failed to successfully complete 20 hours of community service. All right, good luck, sir. Good morning, you're here in 18 CF 13383, charged with violating your probation. I'm going to appoint an attorney to represent you. The allegation is that you failed to pay the state of Florida, failed to successfully complete or remain in drug or alcohol treatment, that you used intoxicants or possessed drugs, to wit cocaine, and failed to make court cost payments. At this time, there's no bond on that warrant, sir. Good luck. Good morning, you're here in 2016 CF 131486 for violating your probation. At this time, I'm going to appoint an attorney to represent you in this case. There's no bond authorized on the warrant. The allegations are that you failed to report as directed, changed your residence without first procuring the consent of your probation officer, and failed to comply with other instructions as given. Good luck, sir. Good morning, you're here in 2020 CF 2296, charged with violating your probation. At this time, I'll appoint an attorney to represent you. There's no bond authorized on this warrant. The allegations are you committed the criminal offense of trafficking in phenethylamines. All right, good luck, sir.
We have the one Creole case. Is that, we're gonna do it this afternoon?
We're still waiting on a Creole interpreter. Okay.
May I inquire about the Hostetler case, Your Honor? Or,
I believe we're waiting on the Creole.
I'm sorry. Well, I was going to ask if Ms. Davis knew James Romer, their date of birth. Is Hostetler's date of birth, the real Hostetler, 11/18/77? And then James Romer's date of birth may be different because it's another person.
January 25th, 1977.
That is Hosteller's real.
75? 1975?
125.77.
Romer's real date of birth
Is 1975?
is January 25th, 1977.
Oh, okay, thank you.
Is Romer. And then the 11/18/77 is Hosteller. And the 15507 belongs to Hosteller. The 6476 belongs to Hosteller. And then the out on bond 14773 is Romer.
The out bond is rumor?
Okay.
The out on bond is rumor?
The out on bond, the 14773 is.
He doesn't need the interpreter? All right. Don't hang up. Let me see. So, tell me your name again. All right, Mr. McCourt. You don't need a translator?
I've been here for 21 years now.
Oh,
I made a mistake yesterday when I asked for one,
all right. You seem to be speaking very clearly.
She told me you was going fast, that's why she want me to. They pre-trial. She told me you're gonna do fast, that's why.
All right, well, here's what I'll say. Let me tell you what we're doing here today, and if at any point you think that you need the services of an interpreter, you let me know, okay? All right. You're here in 21 MM 8634, charged with battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. I see that he has no criminal history.
Yes, Your Honor. The only thing I see is the victim said there was unreported incidences.
So, Mr. Brands, do you wish to be heard on bond?
We would just have you set the standard bond, and in this case, just straight bond.
All right, sir. Your bond in this case is $500 with special conditions. At this time, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow you to return one time with law enforcement to gather your belongings. Do you understand? So do you want me to speak through the interpreter at this time, or do you understand everything we did?
Listen, everything you said.
All right, do you have any questions for me?
No, I'm fine. Thank you so much.
All right, good luck, sir.
Thank you.
Date ready for 33 days?
Yes, Your Honor.
All right, go ahead.
Shayla Davis, 21 CF 14422, granted, notice of non-filing. Anthony Salzgaro, 21 CF 14286, granted, notice of non-filing. Rondazelle Miller, 21 CF 14333, granted, notice of non-filing. Jamel Robinson, 21 CF 13833, granted, notice of non-filing. On behalf of the Office of the State Attorney.
Tyler Brands on behalf of the Office of Public Defender.
Roberto Bennett.
They're not doing the move-ups? Oh, I didn't mean to over move-ups. I don't care about that, but.
You want to do Bennett and Bennett and here and just start with a move up?
I don't know, why are they move-ups? Right, I didn't mean over move-ups. If they need to be moved up for some reason, I don't care about that, but I just meant before all the misdemeanors. Okay, so who's he?
Bennett. And it's case number 2021 CF 15558 AO.
And 2021 MM 8648 AO, he has two. Okay. Sir, you're here charged with possession of cocaine and possession of cannabis less than 20 grams, as well as open container. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $1,000 on count 1, $500 on count 2, and $250 on the open container. With special conditions, you can't possess or consume any controlled substance without a valid prescription or any alcoholic beverages. You can have no contact with any known drug dealers. At this time, I'm revoking your bond in 21 CF 8149.
And the conditions are in both cases, right?
Yes. Thank you. Good luck, sir.
Second.
Welcome to an Econo meeting. You are entering the meeting now.
Good afternoon, counselor. Can you hear me?
Yes, Your Honor, can you hear me?
Yes, sir. All right. Good afternoon, sir. Can you please tell me your name?
Stacy Kirby.
All right, Mr. Kirby, I believe your attorney here. Counsel, if you want to put your appearance on record.
Yes, Your Honor, this is Andre Young here for the accused, Mr. Kirby.
Sir, you're here charged with aggravated assault with a firearm and aggravated battery with a firearm in 21 CF 15247. A warrant was issued for your arrest, so another judge has already found probable cause. Ma'am, do you wish to testify?
No.
All right. Counsel, did you wish to be heard on bond?
Yes, Your Honor.
All right, go ahead.
Thank you, Your Honor. Mr. Kirby, this is an isolated incident. We feel like he has extensive community ties. He's been married for 25 years, 2 adult children. I believe his daughter is present, born and raised here in Orlando. He's a homeowner and a business owner. He owns his own trucking company. No mental health issues. Resources are in place to pay for the bond. Or the post bail, and there are no active cases pending against Mr. Kirby. So we would just ask initially, Your Honor, if the court would consider a direct pretrial, a straight pretrial release of the court discretion.
All right, any response from the state?
Your Honor, state would object to straight pretrial release, given the allegations within the warrant. Also, given that they were firearm offenses. So if Your Honor would like to put him on pretrial release, state has no objection to that, but would ask for bond in conjunction with pretrial release. I do believe Mr. Kirby does have a very limited criminal history. I believe he has this 2021 case. But prior to that, at least in Florida that I have access to, it seems his last case was in 1993, 92, and 89. So he does have a limited history, and the history he does have is quite old. State's main concern is the gravity of the allegations that are within this warrant. It's pretty concerning for both the victims as well as other witnesses, and pretty dangerous for the victims as well as other witnesses that were on the road or witnessed the events. I believe we potentially have at least 2 witnesses who came forward, one who called 911 and one who posted a photo of the incident. And I believe the victim was eventually able to ID the defendant once it was put into a police lineup. I understand Mr. Kirby, I believe, is a truck driver. I don't know where his general routes usually are, but that's also a part of concern for the state, given I believe his truck has a Kansas license plate. I don't know how far his routes extend, and if he spends most of his time here in Florida or in Orange County or further than that. However, he is entitled to a reasonable bond, so state has no objection to that. I'm just concerned regarding the allegations within this warrant are incredibly troublesome for both the victims and the community at large.
I understand the argument. Thank you, counsel. And the court is also concerned, while your client has very limited history, counselor, the history from 1992 is carrying a concealed weapon and firing of a weapon in public, which is shockingly similar to the facts in this case. That's concerning to the court.
While we certainly understand the gravity of what Mr. Kirby is accused of, Your Honor, he also has a side of this story that we feel will have certainly some justiciable defenses to what the accuser is claiming. Like I said, that was a lifetime ago, roughly 20 years prior. He has been an ideal citizen, husband, father, business owner in that span of time. Certainly understand the court and the state's concerns, but it's an isolated incident. My client, according to him, wouldn't be able to identify the accuser if he walked into the courtroom presently. So there's no issue with regard to my client pursuing, intimidating, threatening, or harming this accuser or the witnesses, Your Honor. So it's not, while I understand what he's accused of, the facts don't substantiate, a lot of the concerns that would exist in a domestic or a crime in which the person knew the victim.
All right, thank you, counselor. Here's what I'm going to do at this time, Mr. Kirby. I am going to place you on pretrial release and require that you post a monetary bond. However, I'll reduce that amount significantly. Your bond on count 2 will be $5,000. On count 1 will be $500. With special conditions, you can have no contact with any victim or witness in this case. You cannot possess a weapon of any kind, a firearm or ammunition. I'll require that you surrender this firearm to law enforcement within 24 hours of your release. Because it happened on a road, Ms. May, the court's not inclined to issue any kind of not return. Or is there anything like that the state would be requesting?
No, Your Honor.
All right, Mr. Kirby, good luck, sir. Stay in touch with your attorney, okay?
Thank you, ma'am.
Yes, sir. Thank you, counselor, for appearing. Thank you, ma'am.
Thank you, Your Honor. Thank you, Mr. Kirby. Thank you, State.
Have a nice day.
Same to you all.
So we're going move ups or felony?
I don't want to yell across the courtroom.
You need something? Okay.
Your Honor, if this is Mr. Bolsey or Polsey, may I have a moment to confer?
It's who?
Mr. Polsey or Bolsey? Bolse?
BULCE. We have a new individual out there pulling the inmates, so give us a minute.
Okay.
David Walsey. Oh.
This one, see that? David Walsey, 2021 8620 AO.
Your Honor, he's here on a trespass charge. I did get an offer from the state of an adjudication of guilt, credit time served, and no return. I did have a brief chance to speak with Mr., I believe his last name's Pulse, is that correct?
That's correct.
And he would like to resolve that case. I went over the rights and the repercussions of entering a plea, especially when it came to citizenship and probationary issues. I believe he wishes to resolve that with a no contest plea today, Your Honor.
Please raise your right hand to be sworn.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, Mr. Bowles, there is probable cause for this trespass charge. You had an opportunity to discuss with the attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
All right, sir. At this time, how do you wish to plead to the charge of trespass and occupied structure?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. You can't return to the address.
It's the McDonald's located at 2503 North John Young Parkway.
I'll take no action on his out on bond case. And sir, you have 30 days to appeal in writing. Good luck.
There's a pen right there.
Your Honor, next we have Mr. Brunson.
That's right.
Come on.
Take care, Mr. Pulse. Your Honor, this is Mr. Diamond Brunson. You're on a trespass charge. I have an offer from the state of an adjudication of guilt, credit time served, no return. I believe Mr. Brunson wishes to resolve that with a no contest plea today. I did have a chance to speak with him.
Case number 2021 8650 AO.
Raise your right hand, please.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, Mr. Brunson, you are here charged with trespass on property after warning. There is probable cause. You had the opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
At this time, sir, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the
1 day.
1 day you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay those, and that you not return to.
The Wawa located at 3100 South Orange Avenue.
Yes.
All right, good luck, sir. You have 30 days to appeal in writing.
This is Mr. Miguel Molina, Your Honor.
It's, you want me to say that? Okay. Case number 2021 MM8623AO.
It's a trespass charge, Your Honor. The state's offer is an adjudication of guilt, credit time served, no return to Orlando International. I did have a chance to speak with Mr. Molina in the back, and we went over the rights to be waived and the repercussions of entering a plea. I also handed him a plea form to review. I believe he wishes to resolve that with a no contest plea today, Your Honor.
He has 2 days.
Thank you. Raise your right hand, please.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, Mr. Molina, you are here charged with trespass on property after warning. There is probable cause. You had the opportunity to discuss with an attorney before court the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights? Do you have any questions for me about them?
I'm pleading no guilty. I mean, I'm pleading no contest, right?
I'm about to ask you that.
Okay, sorry. All right, just making sure. Sorry. Oh, no. Oh, my bad. No, I don't. I'm sorry.
It's okay. I just want to make sure you understand.
Yeah, I understand.
All right. At this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. Sir, you can't return to the Orlando International Airport. Good luck. You have 30 days to appeal in writing.
Okay, thank you.
Yes, sir.
We're gonna have Mr. Jose Benitez coming up.
Just a moment, Your Honor, to confer.
Your Honor, for the record, for Mr. Benitez, state did convey an offer of an adjudication, credit time served, and no return. And he is here on 21 MM 8646.
Your Honor, I do believe Mr. Benitez does wish to resolve it today. Let me get it.
He has 2 days.
I did have a chance to speak with Mr. Benitez. I went over the probationary and citizenship issues as well as the rights to be waived. He does wish to resolve with a no contest plea, Your Honor.
Please raise your right hand. Sir,
Raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yeah.
all right, Mr. Benitez, you can put your hand down now. I'm a little bit concerned it's taking you a minute to respond here in court. Is everything okay?
Yes.
Are you under the influence of any drugs or alcohol today? Did he say no? I can't
Said
hear
no,
him.
Your Honor.
Is there anything else going on that may be impairing your ability to understand what you're doing here today?
No.
All right, sir. You had the opportunity to discuss with an attorney the rights you'd be waiving if you enter a plea of guilty or no contest. Do you understand those rights? Do you have any questions for me about them? I can't hear him.
No.
Thank you. All right, sir, at this time, how do you wish to plead to the charge of trespass on property after warning?
Your Honor, would you consider just setting a bond on this?
Yes. Give me one moment. Hold on, sir.
Mr. Benitez, do you have a place where you receive mail, a shelter? You get mail through the general delivery at the post office? Have you worked with the Office of the Public Defender before? Your Honor, I would request ROR, but usually the court requires some address to receive mail. If you're not inclined to set ROR, I would just have you set a $100 bond.
What says the state?
Your Honor, state has no objection to a low monetary bond. It does appear he has at least one prior failure to appear and a recent plea to a trespass.
Mr. Benitez, if I order you to stay in contact with the public defender's office, are you able to do that?
Yeah.
Do you have a phone?
On the phone. I get in contact with them.
Can you make a call at the library or something? Or the shelter? They use a phone there? You can use a phone there. You call this number that I have circled here. Okay. And you stay in contact with us about your case?
Yeah.
All right.
All right, sir, I'm going to release you on your own recognizance at this time, but I will order that you're not allowed to return to the Lynx bus station at 455 North Garland Avenue. Do you understand that? Sir, you need to stay in touch with your attorney, okay? Good luck.
Now leave today?
Yes, sir.
Station. There you go. There you go. Call us. Stay in contact. Thank you, Your Honor.
Yes, sir.
Robert Perry.
You said, what was it?
Robert Perry, Your Honor.
Case number 2021 MM 8631AO.
I did not get an offer from the state here today, Your Honor. I would just have you set a low monetary bond on this. It is a trespass.
Mr. Perry, you're here charged with trespass on property after warning. There is probable cause. At this time, I'll appoint an attorney to represent you.
Mr. Perry, is there a place where you get mail?
Yeah, my parents' house.
Okay, do you know the address for that?
3138 Riverside Park Road.
I'm sorry, what? Say it again?
3138 Riverside Park Road. Any way I can plead out to this today, please?
No, not today, but we're going to try to resolve it later, okay? Riverside Park
Road, yes.
Road.
So
Orlando?
that's on the same street as where the trespass was issued?
Do you know where they picked you up?
Yeah, right in front of Trailer on that side. I just started.
Is that a different house than where your parents
Yeah.
live? Is it about 500 feet or more away from?
No,
It's right next door?
across the street.
All right, Mr. Perry, here's the issue. I'm going to order that you cannot return to the scene for any reason. Do you understand that? So I'm not asking you any questions about this. I don't know why you were at this residence, but you cannot go back. So you can't be confused about residences and go back to this one. Do you understand? Your bond is $500, no contact with the victim, cannot return to the scene. Sir, you cannot possess or consume any alcoholic beverages or any controlled substances without a valid prescription. All right, good luck. Stay in touch with your attorney.
My name is Maureen Samuel. Case number 2021 MM 811AW.
Your Honor, there was no offer on this case. I would just have you, as it is a trespass case, if you would consider ROR a low monetary bond on this as to release conditions.
Why did trespassing in the first place? I was just sitting there.
Ms. Samuel, you're here charged with trespass. I reviewed the probable cause affidavit, and there is probable cause for this charge. I'm going to appoint an attorney to represent you.
Your Honor, state was concerned regarding her mental health history. When I looked up her CCIS, she's been very recently Baker acted, and then several prior times prior to that.
Ms. Samuel, is there a shelter you go to all the time or a place where you get mail?
In the group home.
Do you get a group home? Do you get mail at a place right now?
Mm-mm.
Is there a place you
It's
stay?
stolen. I don't care who take it, but it's stolen. I get Social Security.
But you
With my
know,
disability, with my eyesight, I'm blur vision.
but someone takes the checks in the
But I
mail?
want to increase my vision.
But someone takes the Social Security checks out of the mail? So you do get mail
But I'm
somewhere?
not sure where I sell it before. I got lost track of it. They put me out of the house smoking cigarettes. I smoke cigarettes.
This is a public defender's number, are you able to call us to keep up with what happens? Or you have a phone, or you have a phone you can use?
Mm.
Okay.
So what you gonna do for me today, John? What should I do? Tell me, how should I live my life?
Ms. Samuel, I think what I'm going to do is ask that you be screened for mental health pretrial release.
I'm
See
not
if-
mentally ill. I have blur vision. People was, when I was homeless, they were raping me and trying to kill me and cut me up and all kind of thing. And that's when I told the cops didn't believe me and they took me to Lakeside. I'm not mentally ill. That's the truth. That's what happened. I'm scared to prove it.
I believe you, but I think that there might be some services that we might be able to provide for you, and so that's why I want you to be screened for that program. However, if she doesn't qualify for that program, at this time, I'll authorize that she be released on her own recognizance. But Ms. Samuel, you cannot go back to the Tri-City Center. Do you understand?
Mm-hmm.
You can't go back to Tri-City Center.
And I need you to stay in touch with your attorney.
Can I ask you a question? Is my Social Security still running?
I don't know the answer to-
Appointed by the state because because of my blue vision and my disability. I hope you don't cancel it.
Oh, no, ma'am, I don't do that at all. I don't have jurisdiction to do that. So call the number on that green piece of paper and talk to your attorney about it.
Where I'm going and back in the jail.
Right now, yes.
But I don't know how. Who's gonna call this attorney?
They'll help you.
And I have to come back here with an attorney.
You will not have to come back here.
I'm staying just forever.
Mr. Brands, can you make some notes for your colleagues?
Yes, Your Honor.
Okay.
Name is Herlan Soto.
What's the name?
Case number 2021 MM 8632 AO. AO.
Your Honor, there was not an offer conveyed due to potential other charges to be filed.
That's right,
All
Your
right.
Honor. And I would just have you set a bond on this. As to his out on bond case, I do have an order deeming him incompetent to proceed, and if that has any bearing on your determination of whether to revoke.
It likely would. Counselor, do you have the judge's name and the date that was signed?
Yes, I do, Your Honor. It was on by Judge Gail Adams, 17th of March, 2020. May I show the state before approaching?
Yes, please. All right, sir, you're here charged with possession of drug paraphernalia and resisting without violence. There is probable cause. I'll appoint an attorney to represent you.
I believe they're supposed to be doing other evaluations.
Yes, please. Thank you.
But I would still have you take no action on that out on bond case and set bond in the current charge.
What says the state?
Yeah, there's been a lot of procedural history since that has been signed. That was back in March, was that correct?
Of 2020.
Since that day, March of 2020.
If I may, Your Honor, I think the last note I read was that the judge did allow for competency restoration until December 20th.
There have been several status hearings since that day, countless. And December of 2020, the defendant was found in violation of the conditional release. There's been many correspondence from Aspire. The case is now in front of Judge Blackman. He had a competency hearing on 6/14. And there was a report from Aspire stating that the defendant was not staying in compliance with treatment. I believe there was another letter from Aspire on 8/23/21. And at that hearing, the 8/23/21 hearing, the court was waiting on further reports from another doctor. This one just seems to be not as clear as others, Your Honor.
All right, sir, I'm going to stay your bonds as listed in the affidavit. It'll be $1,000 on each count with special conditions. You can't return to the scene for any reason. You can't have contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. I'm going to take no action on the out of bond case at this time. Good luck.
Hold on, Montel, Gorham.
Case number 2020 MM2433AO.
How you doing, Your Honor?
Good, sir. You're here because a capias was issued for your arrest for failing to appear on a charge of battery. The bond authorized is $2,000. I'll appoint an attorney to represent you. Good luck, sir.
That's why.
Hey, excuse me, Your Honor.
Yes, sir.
Yeah, so last year they released me on this charge, and then they told me to come back to court. I was in another state. So that's why I didn't come to court. They had released me. I didn't know I was supposed to come back to court.
So it sounds like you think you might have some defenses to the failure to appear, but because it's a capias, I can't change it. You'll have to raise those defenses in front of the trial judge. You have a bond. If you're able to post it, you can bond out. I've also appointed an attorney for you, so you want to call your attorney right away and have them schedule a bond hearing in front of your trial judge.
I call this number right here.
Yes, sir. They'll tell you who your attorney is.
When I come back to court.
That's between you, your attorney, and the judge, the trial judge. Good luck, sir.
Donovan Trent Daniels.
Daniels?
What's the last name again? I said Ramos. What's the last name? Yes.
Arraignment?
What's the last name? Say it. Okay. Case number 2021 MM4321AO.
Mr. Brands, your office represents Mr. Daniels.
We'll enter a plea of not guilty, Your Honor.
Division 85 pretrial conference, January 24th at 9 a.m. in 4A.
That's your next court date, sir. Stay in touch with your attorney.
Yes, ma'am.
Good luck.
Good afternoon, Your Honor. I'm Joseph Dyer.
Case number 2021 MM51AE.
Mr. Brands, your office represents him.
Yes, Your Honor, we'll enter a plea of not guilty here as well.
Division 85 pretrial conference, January 24th at 9 a.m. in 4A.
Your Honor, may I say something, please? Is this for the battery and the petty theft?
Yes, sir.
Okay, well, Mr. Andrew is my public defender in this case. I already did 85 days. Can I resolve this today with a no contest plea? Because I keep getting arrested. I've got 85 days in on this. I want to resolve it. I just want to get it over with.
I understand what you're saying.
Enter a plea today?
You cannot, and I'll tell you why. Because the nature of this charge is battery and there's a victim involved, the victim let me finish. The victim has a constitutional right to be present at the hearing. But because this is just an arraignment on the charge, the victim probably wasn't notified to be here today. So you'll have to do this in front of the trial judge when the state has the opportunity to notice the victim.
Well, they already came up with I'm not guilty anyway, but they already came up with plea for time served. They already, the state already came up with this.
Right, but it has to be scheduled for a hearing when the
front of
victim can come. Now, they don't have to come and they may not come,
I don't think so.
but because they have a right to be there, I can't do it without them.
Oh, okay.
That's why, I'm sorry.
January 24th.
But call your attorney, they may be able to schedule it sooner.
Yeah, you know, Andrew,
gonna email him
can you
today.
talk to him,
Yes,
have
I'll
him
email
come
him
see
today.
me as soon as
Yes, I
possible?
will.
Thank you. Thank you.
Yes, sir, good luck.
Deshaun Jones.
Case number 2021 MM7890AO.
State did convey an offer of an adjudication of credit time served, no return to Chevron at 3600 South John Young.
And Your Honor, I did have a chance to speak with Mr. Jones about that offer, as well as the repercussions of entering a plea, especially probationary and citizenship. I gave him a plea form to review. We reviewed that. I believe he wishes to enter a no contest plea on this charge today.
Raise your right hand, please.
You swear to tell the truth, the whole truth, and nothing but the
Yes.
truth?
Yes.
All right, Mr. Jones, you had the opportunity to discuss with your attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yeah.
Do you have any questions for me about them?
Oh, no.
At this time, sir, how do you wish to plead to the charge of trespass on property other than structure or conveyance?
Oh, no contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 32 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. I'll also order you're not allowed to return to the address the state just put on the record. All right, good luck, sir. You have 30 days to appeal in writing.
Okay. Okay. Percy Joseph.
Case number 2021 MM8383AO.
This is the public defender. Will enter a plea of not guilty.
Division 82 pretrial conference, January 10th at 10:30 a.m. in 10B.
Mr. Joseph, you're here charged with petty theft. You want to call your attorney right away, okay? That was your next court date.
Okay, I really don't even know. Okay, it's petty theft, but I don't know which one it is because I was in here for a prior case. But,
I don't know either because I don't have the probable cause affidavit. Let me ask the state. Do you have the facts?
Yes, Your Honor. On or about November 27th of 2021, law enforcement responded to Al's Food Store on 916 South Paramore Avenue. It is alleged that a black male entered the store and attempted to purchase a carton of cigarettes worth $80. The debit card declined. The male reached over the counter, grabbed the cigarettes, and ran out of the store, passing all points of sale. All events occurred in Orange County, Florida.
Yes, sir. Good luck.
Lawson.
Your Honor, we do not represent Mr. Lawson in this petty theft, if appointed. May we be?
This is case number 21 MM7385.
I have that you are appointed, but if not, I will appoint you at this time.
3785, right? Okay.
8-5, yes.
We'll enter a plea of not guilty here, Your Honor.
It's a VOP.
We'll enter a denial, Your Honor.
Division 80 VOP status, December the 21st at 9:30 a.m. in 9C.
It's at 1221.
Yes.
Thank you.
Yes.
We're moving to felonies now. Your Honor, this is Mr. Andrew Chico.
Case number 2021 CF 15539AO.
Sir, you're here charged with burglary of an unoccupied dwelling. There is probable cause. I'll appoint an attorney to represent you.
We would just request a reasonable bond on this, Your Honor.
Your bond is $3,500 with special conditions. You can't return to the scene for any reason. You can't have contact with any victim or witness in the case. You can't possess a weapon of any kind, firearm, or ammunition. At this time, I'm revoking your bond in 21 CF 12621 and 21 CF 12217. And I'll appoint the public defender in case you were not. You are? Okay, good, thank you.
Wesley, do.
Case number 2019 CF 10725AO.
Mr. Dew, you're here because a capias was issued for your arrest for failing to appear for a trial on a charge of trafficking in methamphetamine. At this time, there's no bond, and I'll appoint an attorney to represent you.
Judge, he still has Thomas Murphy on. I don't have it.
Oh, you have an attorney? Hold on, let me see.
Actually, I do.
If he's present.
Welcome to an Acano meeting. You are entering the meeting now. You are the only participant.
Sir, I don't have your attorney on the line, so you need to contact him right away. All right, good luck.
Ashton Doucette.
Case number 2021 CF 15551AO.
You're here charged with aggravated assault with a firearm and carrying a concealed weapon.
Your Honor,
Yes. I'll appoint an attorney to represent you.
as to probable cause on count 2, I don't know if there were any facts in the four corners of the arrest affidavit that indicated that the weapon was concealed.
What says the state?
Your Honor, in the affidavit, it says the firearm was concealed from ordinary sight of another person located in the floorboard of the back seat of her vehicle. When law enforcement arrived and made contact with Ms. Doucette.
But I don't believe there was a narrative that, I think that came later after they had already detained her.
I'm sorry, I don't understand your argument, Mr. Brands.
In the facts of the arrest affidavit, he stops the car and then I believe he arrests her and then charges her with a concealed weapon because he said there was a concealed weapon, but there was no facts in the narrative that I thought appropriate. That when he stopped her and was looking around in the car that he found a concealed weapon.
I'm sorry, go ahead.
I'm sorry. I don't believe the car had to be stopped. I believe it was already sitting at the location with the defendant sitting in the driver's side. When law enforcement arrived, she came out of the driver's side door. All the victims and witnesses pointed to her, saying that she is the one who threatened them with a firearm. Law enforcement arrested her for having a firearm in her vehicle, and they located it in the floorboard of the back seat, which was concealed from ordinary sight of another person.
Right, I think that the paragraph that says the firearm was concealed from the ordinary sight of another person and then it was located on the floorboard of the back seat, I think that's sufficient for probable cause. You may have a good argument later, Mr. Brands, but I do find probable cause here. What says the state has to bond?
Your Honor, it looks like the defendant has very little history, and if any, it's out of state history from, it appears, Louisiana. However, state would ask for a reasonable bond with no contact and no return. She does otherwise qualify for PTR, so if you're otherwise inclined to put her on PTR, state would ask for bond with PTR.
Anything from the defense?
Just a straight reasonable bond, I believe it would be sufficient, Your Honor.
I do see that she has no Florida history, it says there's an out-of-state history in Louisiana, so that concerns the court for her ties to this community. However, since there is no history to consider,
I believe she also still has a Louisiana driver's license. I don't believe she has one, at least that's listed from Florida. So state's concerned about her community ties.
does it say that in the affidavit?
It does it on the front paperwork, Your Honor. Her driver's license is a state ID from Louisiana. If she otherwise had a Florida, law enforcement would put a Florida ID.
Man, that is concerning. All right. Ma'am, at this time, your bond is $5,000 on count 1, $500 on count 2. With special conditions, you can't possess a weapon of any kind, firearm or ammunition, and you can have no contact with any victim or witness in this case. Do you understand what no contact means? All right, good luck, ma'am.
Your Honor, state would also ask for a no return to Indigo West Apartment. I don't believe that is her listed address.
All right, I will order that you're not allowed to return there. And ma'am, you cannot drive in Florida without a valid Florida license. Do you understand? I think the law requires, I think our statute says that if you're here for long, if you live here longer than 10 days, you have to change your license, but I could be remembering that wrong, but yeah, look that up because you need to have a valid Florida license. Okay, good luck.
Anthony Jerome Dumas.
Case number 2020 CF 12891AO.
Sir, you're here because a capias was issued for your arrest for failing to appear on charges of petty theft. There's no bond authorized on that capias. I'll appoint an attorney to represent you.
Can I ask a question?
You can ask anything you wish.
Okay, the judge that, do I have to? I don't know how to say. The judge that, appointed me this first time I was for petty theft, do I have to get in touch with him for him to give me a bond or something?
Yes, sir. Because it's a capias, I can't change it.
But could I get his name or whatever?
So if you call the number on that piece of paper, that's for your attorney. Your attorney will file a motion in front of your trial judge.
Okay, ma'am.
Hold on one second. I can tell you who the trial judge is.
I believe it's Judge Wilson, Your Honor.
All right, it'll be in front of Judge Wilson.
Okay, thank you.
Yes, sir.
Jean Fenelon.
Case number 2021 CF 1555280.
You're here charged with driving while license revoked as a habitual offender and no motor vehicle registration. At this time, I'll appoint an attorney to represent you. There is probable cause. Your bond is $2,500 on count 1, $500 on count 2. I show that he's out on bond, Mr. Brantz.
Yes, Your Honor. Defense has no argument at the time. At this time.
And that case has been filed on, Your Honor.
I'm sorry?
It has been filed on.
You can revoke and double if you see fit.
What says the state?
Yeah, I'll leave it within your discretion. Allegedly, this occurred back in August with 2 other co-defendants. The defendants were observed walking away from a stolen vehicle. One of the other co-defendants had the keys, and the defendant just had a black pistol without a concealed permit. I'll leave it within your discretion, Your Honor.
I'm going to take no action at this time. Good luck, sir.
Hold on. Hey, how you doing, Your Honor? Montel Gorham.
Warren?
That's the one we just did? Yes. Sir, we had to bring you back because I didn't notice that the judge who issued the capias added conditions in 20 MM 2433. You can have no contact with the victim. You cannot possess a weapon. And I don't understand this last one.
That's why I was, the last part I was confused. I only got the first two.
Did you read this capias?
I just pulled it, I went back in the files. Is this Mr. Gorham?
Yes. I have no idea what that last one means. All right, Mr. Gorham, you understand those conditions? All right, so your bond is still $2,000. I still appointed an attorney to represent you. But if you bond out or while you're in custody, you can have no contact with the victim. When you bond out, you can't possess a weapon of any kind. Do you understand?
Okay, yeah, they had released me on this charge. The guy, he choked me, like they was choking me. I couldn't breathe when I was they was choking me at the Greyhound station. And then I told him to get off of me. I was trying to have church with my Catholic St. Elizabeth. And then they was choking me, and they said I was trying to touch. I tried to hit them, but I didn't. So they released me last year on this charge, a long time ago.
The state still has a pending charge, and the judge issued a capias because you failed to appear for
I
arraignment.
pled guilty to this charge already, and I did my time.
Let me ask the state, what do they see?
No, Your Honor, it's still open. It was filed 3/23 of 20, and then he failed to appear at arraignment on 9/3/20, and the capias has been active since.
Yeah, I made sure I pled guilty to that charge, and I did my time. I promise you.
You didn't to this one. It might be a different case.
This is the one that happened at the Greyhound station. Am I correct?
The information charges that on the 31st of January,
Yeah, that was my
you
birthday.
battered O'Daney Porter.
Yeah, that was at the Greyhound station because when I pled guilty, I did my time.
Your Honor, it's open both in our system and the clerk system.
Right, the clerk system does not show any guilty plea here, so you're gonna need to contact your attorney right away.
So why am I coming back to the courtroom for?
Because there were additional conditions on the capias, and I wanted to make sure you understand them.
Hey, can you figure this out, lawyer? Because I pled guilty to this last year and I did my time for it. But you already knew that I came here. Why you didn't do that before? I can still bind out, or oh, this number I'll be speaking to.
Good luck, sir.
Alexis Fernando Guzman.
I'm sorry, what's your name?
Alexis Fernando Guzman.
Case number 2021 CF 1554280.
You're here charged with grand theft of a motor vehicle and burglary of a conveyance. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $1,000 on count 1, $3,500 on count 2. You can have no contact with any victim or witness in this case. You can't possess a weapon, firearm, or ammunition. You can't return to the scene for any reason. And at this time, I'm revoking his out on bond cases. Good luck, sir.
Your Honor,
Yes.
there's private counsel here for Mr. Liu. I was wondering if a clerk could print the warrant for Dan Tao Liu for counsel to review.
He's just telling me that.
Did you print the warrants for them? We can look.
The only thing I have, I'm sorry?
She's gonna look and see
Oh.
if it's sealed.
Take it. The only thing I have was on my computer. I don't have a printer.
Your Honor, if I'm thinking correctly, I believe this is one of the victims invoked Marcy's.
All right, if that's so, then we will not be able to print it, but we'll check right now.
If I could have some access, Mark Longwell for the record, I'm going to be representing Mr. Liu, and he certainly does have due process rights regardless of Marcy's. I'd just like to review it for probable cause. I'm sure the court already has.
I have.
So whenever you're ready, you can address it.
All right, are we bringing his client in soon? I don't know what that means.
We can bring him in when you're ready.
Oh, I see. Okay, thank you.
Case number 2021 CF 5567AO.
Sir, you're here because a capias was issued for your arrest for failing to appear for a hearing on charges of possession of methamphetamine and possession of drug paraphernalia. There's no bond authorized. I'll appoint an attorney to represent you. Good luck, sir. Did you check?
Shantavius Flanders Cabral.
Give me one moment. Oh. Yes.
Case number 2019 CF 15481AO.
Ma'am, you're here because a capias was issued for your arrest for failing to appear for a hearing on a charge of aggravated assault with a deadly weapon. There's no bond at this time, and I'll appoint an attorney to represent you. Please tell me your name.
Mark Frazier.
Case number 2021 CF 14524AO.
You're here charged with burglary of a structure, grand theft, and criminal mischief. A warrant was issued for your arrest, and an information has been filed. At this time, I'll appoint an attorney to represent you. Your bond is $3,500 on count 1, $500 on count 2, $1,000 on count 3. You can have no contact with any victim or witness in the case. You can't return to the scene for any reason. You can't possess a weapon of any kind, firearm, or ammunition. Good luck, sir.
Jeffrey Fuller refused.
Case number 2021 CF 15543AO.
I'll find his refusal a willing waiver of his appearance today. Mr. Brandt, I'll appoint your office.
We'll waive his appearance as well, even though you found his refusal.
Did you wish to be heard on this? It's the arson of conveyance.
Yes, I did have some issues with the interview, but I believe that's for a motion to suppress argument.
I agree. There is probable cause. Does the state wish to be heard on bond?
Your Honor, the arson of a conveyance is an F1 as currently charged. State would just ask that you set a reasonable bond He does appear to have some history, however, does seem to be approximately 10 years old. However, he also does have some violent history, as well as other grand theft motor vehicles. So state would just ask that you set a reasonable bond, taking into account the gravity of the charges within this affidavit.
All right, thank you. His bond on count 1 will be $25,000. Count 2 will be $500. With special conditions, he can have no contact with any victim or witness, can't return to the scene for any reason, can't possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request?
State would also ask for no return to Fields BMW.
I said no return. Yeah.
I didn't know if the no return was to the CVS pharmacy where this was actually happened.
I'll say no return to all scenes.
Are you ready for the next case, Your Honor? This is, I believe, Miss Jasmine Gonzalez.
Case number 2021 CF 15576 AO.
Ma'am, you're here charged with sale or delivery of fentanyl and possession of fentanyl. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $15,000 on count 1, $1,000 on count 2. With special conditions, you can't have contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription.
Carlos Grimes.
Case number 2021 CF 15555 AO.
You're here charged with possession of cocaine and resisting an officer without violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, $500 on count 2. With special conditions, you can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers.
Your Honor, this is Mr. Hulan Hargrave.
Case number 2021 CF 14908 AO.
If I may have a moment to confer.
Yes.
Thank you, Your Honor.
All right, sir, you're here because a warrant was issued for arrest, charging you with robbery with a firearm, aggravated assault with a firearm, and grand theft. Another judge has already found probable cause. I am appointing an attorney to represent you. Does the state wish to be heard on bond?
Yes, Your Honor. Given that count 1 is a first-degree felony that's punishable by life, state's asking that you hold him no bond pending an Arthur hearing instead of reasonable bond as to count 2 and 3.
I would have you, Your Honor, find proof evident presumption great before holding our client no bond. Even if you do find proof evident presumption great, that just means that Mr. Hargrave is not entitled or does not have a right to bond. You can still set a bond in this case. I believe it is the state's burden to show that there is proof evident presumption great, but if I do have some arguments as to the 4 corners of the warrant, if the court would entertain any of those.
I'm happy to. Did you discuss with your client the effect of you asking the court to make this determination today?
Yes, and I'll repeat the gist of what I was talking to Mr. Hargrave about, that if the court finds proof evident presumption great, they can hold you no bond. If I don't make an argument, they can hold you no bond, but there's a split in case law that if you do a finding of proof evident presumption great today, you might not have this full evidence hearing downtown called an Arthur hearing with your attorney. I think you do get an Arthur hearing downtown, but there are some attorneys that don't. The legal interpretation is that you might not get a full hearing downtown. So, and I believe you wanted me to make an argument today to set bond if possible. And for the record, I will do that. I will request the court find a proof evident presumption great finding. But it is our opinion that he is still entitled to a full evidentiary hearing, an Arthur hearing downtown with his attorney.
Yes, I understand. And Mr. Hargrave, I want to make sure that you understand everything your attorney said is correct. What that means is the judge downtown may disagree with your attorney, and the judge downtown may not allow you to have a full evidentiary hearing again. You understand that? All right. Go ahead, Mr. Rance, with your argument.
Tell them what's in the warrant. Your Honor, as we discussed earlier today, we know that a proof evident presumption great finding is one that's beyond that of reasonable doubt. Reading the arrest warrant, the one piece of evidence they've used to pick up Mr. Hargrave on this was some DNA found on a discarded shirt, very far from the kind of certain high standard that's required in a proof evident presumption great finding. There is video of someone running away from the alleged robbery, but there were no facts that indicate that the person on that video was identified as Mr. Hargrave, nor was that person in the video holding a gun, which the facts do indicate that a gun was used in the robbery. The victims were given an opportunity to identify the alleged assailant through a photo lineup. They could not identify either victim. There were 2 victims, could not identify anyone in the lineup. So I would have you consider that if this was put to a jury, that there would be gaps in the evidence, gaps in the narrative, linking this crime to Mr. Hargrave, therefore establishing some reasonable doubt for those jurors. So I would have you set a bond in this without finding proof evident presumption great, as there isn't.
All right, what says the state?
Your Honor, again, it's purely speculative on what a jury would do with this. We're far from that time at this point. It's alleged within this warrant that this occurred approximately May 13th of 2021 at 1 a.m. The victims testified that they were walking westbound when a black male approached them, pointed a gun at them that they believed was a .380, demanded his jewelry, and received approximately $2,000 worth of jewelry from the victim's person. They described the suspect as 6'2" black male wearing a black shirt, black pants, red shoes, and a black do-rag. The defendant was then seen on the city cameras leaving the scene, walking on Magnolia, and removing the black shirt to reveal a white tank top underneath. These city cameras were at the same time and in the same location as this event. The canine was deployed. The was found, but the suspect could not be located. The victim testified to law enforcement that the gun had a flashlight attached to it. Approximately May, June, July, 6 months later, in November of 2017, there was a CODIS hit on that shirt that was left at the scene, and it did match that of Mr. Hargrave. State would contend that it was 1:17 a.m. There was allegedly no one else within the area, and the defendant, seen on the video, matched the description of the person that the victim said did it. In regards to counsel's argument that a lineup was given to the victims, they were not able to identify the defendant. That is what is stated within the warrant. State would contend that, again, it was about 5-6 months later, and arguably was 1:17 a.m., so probably also pretty dark. However, there was a DNA match, which matched the defendant, as well as his other identifiable factors, matched that of which the victim stated that he is approximately 6'2", and a black male, and was seen arguably within the area. For a robbery with a firearm, state has to prove that the defendant took something from person. In this case, the defendant arguably took the diamond ring, a necklace, a graduation ring, and a G-Shock watch. 2, it was by force, violence, assault, or putting in fear. Was in the course of the taking. State would contend that the use of a firearm, pointing the gun at them and demanding these items, would put a normal person in fear of force, violence, assault. The property was of some value. The defendant, or the victim, said that the diamond ring was about $1,200, the necklace was about $400, the ring was about $400, and the watch was $185. And then the taking was with the intent to permanently or temporarily deprive the victim of their property or the benefit to it. As he fled from the scene and did not return the property or drop it, so contend that that's also present within this case. The state would argue that there is enough for proof of presumption grade at this time. And when asked that you said no bond as to count 1.
So before you continue with your argument, let me tell you where I am. I think that there is proof evident presumption great that a robbery with a firearm, aggravated assault with a firearm, and grand theft occurred in the 4 corners of this affidavit. The issue, I think, for the court right now is the identification.
Mine as well, Your Honor.
All right, so I just didn't want you to spend a lot of time arguing about the elements of these crimes. I think they're very clearly laid out in this affidavit. I find that's proof evident presumption great. However, I want to reread it again as to the identification of your client. So if you have any arguments about that,
Yes, Your Honor.
I would love to hear them.
Yes, Your Honor. I also don't have an argument as to the elements of the charge. It is mostly an identification issue. I don't believe a gun was recovered that matched the gun used in the crime from Mr. Hargrave. I don't believe the jewelry was recovered from Mr. Hargrave. Again, the victims could not identify Mr. Hargrave in the photo lineup. And again, our DNA can be pretty much anywhere. Hair falls out, nail clippings, things can get attached out in the world. I don't know how. If this was a trial, I would probably go into that, how that one piece of DNA may or may not have arrived there for a CODIS pickup. Again, I don't have all the evidence here to make a full argument here as to those forensics. But just the identification element alone, I think, is enough to allow Mr. Hargrave to have a bond on this.
All right, is there anything else from the state on the issue of the identification?
Nothing that I haven't already said, just that the victims identified a 6'2" black male wearing the black shirt, black pants, red shoes, and black do-rag. The camera caught a black male wearing those things fleeing from the area on foot at exactly that time. They stated no others were, there's no indication that any other people were in the area. Watching that camera, they see that male matching that description that the victims gave, drop a shirt, then they recover that shirt, and it only has the defendant's DNA on it. Counsel went into, well, these other things were not found. That's not in bearing on this court. We do have a shirt that matches the DNA of the defendant in the area that they watched flee from the scene on camera. That otherwise matches the description given by the victims.
Counsel, you said it only has the defendant's DNA. Can you point me to that in the affidavit? I see where it was sent to the crime lab. There was possible DNA, and then it says there was a DNA CODIS hit on the suspect clothing.
I believe that's the only CODIS hit that was made, Your Honor.
I believe so. I think it was the fourth from last paragraph, maybe. It says based on DNA CODIS hit, and then they go into why they're using that piece of evidence as their foundation to charge Mr. Hargrave with all this.
And that's reasonable. I mean, I think it's clearly probable cause.
I would agree.
Honestly, I think it's beyond reasonable doubt.
I would agree with the probable cause determination. I would not agree with the finding of beyond reasonable doubt that it was Mr. Hargrave. Forensics can be mislabeled, can be tampered with. Again,
Well, but if you're alleging tampering, that is your burden then to prove.
which I'm not. Again, if I was in trial, this would be a different story.
Right.
Just arguing for bond here.
So there's a video surveillance that shows a man who matches the description that the victims give, that also matches the description of your client. The video shows him running from the scene. The video shows him discarding the shirt.
We don't know that for sure, Your Honor.
I said shows the person matching the description.
That's right.
I didn't say your client.
I'm sorry, thank you.
He matches the description of your client, and he matches the description given by the victims running from the scene of the robbery. We see that person on the video discard the shirt, right? That's what it says in the affidavit.
Yes.
Law enforcement goes straight there, gets the shirt. Is it possible the shirt could have someone else's DNA or somehow got your client's DNA on it some other way?
The alleged person could have bumped into Mr. Hargrave, shaken his hand, went to a bar together. I'm not sure.
Right.
These are all great reasonable doubt questions I would pose to a jury.
We'll see, but there's a difference between possible and reasonable, right?
That's right, Your Honor.
Lots of things are possible. Not everything is reasonable.
But beyond a reasonable doubt means over 95% certain that this person.
There, you cannot put a quantifiable number on it.
I'm not comfortable with a number. However,
It is a very high burden.
I've read this affidavit now several times, and I've listened to the arguments from both sides, and I think there is probable cause. I think beyond all reasonable doubt, it's your client. I'm not going to find proof evident presumption great. What that means, Mr. Hargrave, is whereas you would not normally be entitled to bond, I will now give you a bond on this charge.
Your Honor, may I be heard on bond?
Yes, please.
Again, he is charged with an F1 that is punishable by life. Second to that, he does have Florida arrest for being a fugitive. He has an extensive out-of-state history for several violent crimes, other firearm offenses, at least 6 prior VOPs showing an inability to comply with court orders. And he's currently has a warrant out of North Carolina, also for a robbery charge. So since Your Honor is inclined to set bonds, they would ask for a bond, taking all that into account, as that I'm very concerned about his willingness to come back and deal with these court proceedings, likely given the gravity of being charged with an F1 that is punishable by life, that he already has a fugitive warrant, and has a prior fugitive arrest and all those prior BOPs.
All right, Mr. Brantz, anything you'd like to respond to that?
As he is entitled to bond at this point, I would just have you set a reasonable bond under the circumstances.
All right, I do show all of the facts that the state just stated. The court is concerned, Mr. Hargrave, about your out-of-state criminal history, the fact that you're wanted currently out of at least one other state. Hold on, sir. I'm not asking you anything. You're not required to respond. You can, but everything you say is being recorded and can be used against you later. I'm just telling you my findings on the record. You may want to talk to your attorney before you say anything.
Just a moment, Your Honor.
No, I just wanted to make sure you didn't write that. No, I didn't say that. Okay.
Thank you, Your Honor. No comment.
All right, thank you. Because one of the purposes of bond is to secure the presence of the defendant for future court dates, as well as the severity of this offense. At this time, sir, your bond on count 1 will be $100,000. Your bond on count 2 will be $5,000. Your bond on count 3 will be $5,000. With special conditions, you can have no contact with any victim or witness in this case. You can't possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
Thank you.
Travis Hill.
Case number 2021 CF 1552780.
Sir, you're here charged with possession of a concealed firearm or weapon by a convicted felon. There is probable cause. I'll appoint an attorney to represent you.
Yes.
Just a moment. He's not on probation?
No, he's not. He's not on probation.
So was he released in 2017?
2019.
Was he sentenced for premeditated murder in 2017?
Yeah, that was his last conviction, and it shows that those were the same charges that he was in DOC on, released 2019.
I was on probation. 2014, I was on probation and I violated my probation, came back 2017, got out 2019.
All right, so, okay, thank you. Okay. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $5,000. You can't possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
You also can't possess or consume any controlled substance without a valid prescription.
Yes, ma'am.
Good luck, sir.
Your Honor, Kelvin Houston bonded.
Thank you. Come on up, counselor. You want to put your appearance on the record and we'll start addressing this case?
Yes, good afternoon, Your Honor. My name is Mark Longwell. I'm here present with my client, Dan Tao Liu.
This is 21 CF 15494. Mr. Liu, a warrant was issued for your arrest, charging you with kidnapping and attempted sexual battery. Another judge has already found probable cause in this case. Counsel, did you wish to be heard on bond?
Yes, Your Honor.
All right, let me ask first the state.
Your Honor, count 1 is a first-degree felony that's punishable by life. State's asking that you hold a no bond pending an Arthur hearing.
All right. Mr. Longwell?
So I do not have the benefit of having seen the warrant itself or the affidavit for the warrant. I'm not sure what the allegations are that are contained. I'm surprised that is a F1 PBL. I'm not sure which one is count 1 and count 2, because here on the jail roster it has listed attempted sexual battery, 12 years of age or over. That is not an F1 PBL as far as I know.
That's count 2. You're
Okay.
correct. Count
There
1
is
is
a-
the kidnapping.
Okay, and I only thought it was under certain instances is that an F1 PBL. I'm not sure how they've charged it, but this is not a victim under 13 as I understood it, or some other issue that would make it an F1 PBL. Regardless, I don't have the benefit, and like you said, another judge has apparently reviewed this case for probable cause. So as far as bond goes, I can tell you this. I know Mr. Liu. He lives here locally. He works here locally. He has substantial ties to the community. He's not a flight risk. He has hired my firm, and we will be representing him to address these charges. He wouldn't take that step or invest that sort of money if he didn't intend on addressing these charges, and his intentions were just to flee. He has no significant prior criminal history of convictions as far as I'm aware. And as such, I would ask you, regardless of whether there's proof evident presumption great, which I'm not even prepared to argue at this point because I don't have the benefit of reviewing the warrant, I would ask you to use your discretion nonetheless and impose a bond.
All right, let me ask the state for your response as to the statute and the bond request.
Your Honor, in the statute covers both kidnapping and kidnapping a child under 13, saying that is aggravating circumstances. As charged, 787.01, kidnapping is forcibly, secretly, or by threat, abducting, imprisoning another person against their will, and either holding for ransom, committing or facilitating the commission of a felony, inflicting bodily harm, or terrorizing them, or interfering with a governmental political function. Part B of that, which is what the defendant is not charged with, is confinement of a child under 13 against their will. But subsection 2 is a person who kidnaps a person is guilty of a felony of the first degree, punishable by imprisonment by a term of years not exceeding life, as provided in 3 other subsections. The kidnapping statute covers both kidnapping and kidnapping under 13. He is charged with 1A, which is not a child under 13. I believe the victim was of age, well over 18. However, a kidnapping as charged with 1A is a life felony that is an F1.
Is it a life felony or a PBL?
It is punishable by confinement of life.
So it's a PBL and not a life felony. I think he would be entitled to bond under that circumstance.
He's not entitled to it. You can make an argument, but he's not entitled to it.
Okay.
Because it's punishable by imprisonment for a term of years not exceeding life.
Well, regardless, I would ask you to exercise your discretion and grant him a bond based upon his lack of flight risk or threat of harm to the community.
May I respond, Your Honor?
Yes, I would like to know, was the victim notified about this hearing today?
I'm not sure, Your Honor.
I was told earlier by the state that Marcy's law was invoked, which means there should have been a victim notification.
I thought it was this case. I may be mistaken.
No, it is this case.
Is it this one?
Marcy's law was invoked.
Do you see that within the affidavit?
I don't right this minute, but I'm looking right now. But I asked the clerks earlier, and they checked and said that it was, so I'll find it right now. But Can you tell me, was the victim notified of this hearing?
I don't think so, because we don't have access to the information in the clerk court, and the officer didn't provide any victim notification, so we don't have any access to the victim contact information or anything.
All right, thank you. Sorry, everyone was looking at the wrong case. Marcy's Law was not invoked in this case. Hold on, I'm gonna make sure. I'm gonna review the affidavit right now.
I don't see it within this warrant.
However, because the victim was not notified of this hearing and your client is not entitled to bond, counselor, I'm not inclined to grant a bond. The victim has a constitutional right to be heard. Let me ask if the state is objecting to bond.
Yes, Your Honor, at this time, due to the allegations within the warrant, the state has concerns regarding the several threats to kill both the victim and her husband. State also has concerns regarding the defendant allegedly gave the victim approximately $260,000 over the past 8 months or so. So state's concerned regarding his ability to flee if possible. State's concerned regarding when the defendant called the victim multiple times, she finally answered. He said he was coming to the house. The victim was too scared to remain in her house, ran across the street because she was too afraid. She feared that he would rape her and leave her, and she would not be able to get out of the house. After the defendant allegedly arrived on scene, there was arguably a battery and a sexual battery between the two that ultimately resulted in a kidnapping, where the victim had to open the door and jump out of the moving vehicle to escape so she could call 911. So state is at this time objecting to a bond, given the fear for the victim as well as the safety of the community in Orange County.
May I be heard on a couple of matters, Your Honor?
Yes, sir, please.
First of all, my client is entitled to a prompt first appearance, which he's receiving today, but I believe it should be a meaningful first appearance where not only probable cause determined, but bond considerations are made. I understand that the victim has a right to notification, and it's unclear whether the victim has or does not appear, I guess, that the victim has received that notification. If the court is inclined to reset this matter, I would ask that it be done so promptly and notification can be made, and whether the victim or alleged victim, let's say, chooses to appear or not will be obviously up to that alleged victim. Just from listening to the state's recitation of the facts, which I'm only going on what that has, again, I haven't seen all the alleged facts, there's obviously some sort of, this is not a random allegation of some sort of break-in, rape, kidnapping. This is an ongoing relationship that's close enough that apparently my client has loaned this person over $250,000 within the last several months, which usually leads to some sort of dispute between people from my experience when that happens. So I'm not sure if that's going to constitute a motive for these claims or not, but because it's too early, but I certainly see concerns about that already just listening to that. And if there are statements within that warrant, as the assistant public defender in the courtroom was kind enough to clue me in as I was waiting, there appears to be some statements where she made comments that she voluntarily was willing to go with him and participate in some activity on that occasion. And if that's the case, then there's a big question about whether this would even constitute kidnapping. There's a difference between her going voluntarily and then deciding at some point she wants to bail out or whatever the facts may be, and being kidnapped in the classic sense of that term.
So just for your benefit, I'll read some of the affidavit to you. The victim said she thought maybe she could calm him down if she talked with him. However, when she approached the defendant, he grabbed her by the hair, started striking her in the back of her head 2 times. Then he began shaking her head back and forth. He then grabbed her by the neck, forcefully shoved her to the ground by her neck, then straddled her body as he placed his hands around her neck and squeezed until she could not breathe. And then he said, "I want to kill you now." Before she blacked out, he released the hold on her neck and began to strike her in the face. That's when he reached under her clothing. In an effort to calm him down, the victim told the defendant it was too cold. She would have sex with him if they could go somewhere else. He allowed her to stand. Then he grabbed her by both arms so she would not get away and shoved her into his truck. And that's when he started to drive away. So that's the kidnapping.
Is there anything contained in there of corroboration, or is it purely a recitation of facts by an alleged victim? Witnesses or injuries or photographs of injuries or DNA samples or anything?
Is there anything, Ms. May? I'm going back to read again.
No, Your Honor. But again, PC is not at issue.
Right, it is not. It's already been found.
But regardless, I mean, obviously PC can be based on testimony alone or
right,
recitation of testimony. But clearly this is a situation of uncorroborated testimony, it sounds like.
I mean, further discovery will come at a later time. I mean, we don't have everything. We don't have access to everything, just an affidavit at IA. That's standard procedure.
Right, that's all I have at this time. This all allegedly took place on December 2nd, 2021.
Which was over 5 days ago, allegedly. And within that time, law enforcement, I guess, hasn't informed her that there was a warrant or an arrest made?
I don't know the answer to that. I would imagine they're not notified every time a warrant is served. That's the court's concern. So in a typical domestic battery or even just a battery case, what will happen is we have a division here at the jail that contacts the victims and they have the right to appear. Probably 50% of our domestic cases, the victims do appear. I don't know, 10 or 20% of the non-domestics appear. But in warrants, they don't always notify the victim. And that's what I was verifying with our representative from pretrial release. In this case, the victim was not notified by the jail because they don't have her contact information. So I have no way to know if she was notified of this hearing.
And if I may, the only concern that I would urge the court to consider is obviously Marcy's law represents one perspective of interest within the law, which is that of an alleged victim in a case.
Right.
But the competing interest, which is not overridden by Marcy's laws, are the rights of an accused. And that's what I'm hyper-focused on today, just so you understand.
Rightly so.
Right.
As is the court. I of course have to balance all of those rights.
Right.
I'll tell you, counselor, if this was not a punishable by life offense or a life felony, if it wasn't one of those, I would absolutely agree with you. We would hold the bond hearing and I would set bond conditions, whether she was here or not. But in this case, your client is not entitled to bond. Now, you are correct. I can use my discretion and give him a bond anyway. But I'm loath to do that without having also ensured that the state protects the victim's constitutional right to be heard at that hearing. So typically in these cases, as you are aware, what would happen is you would likely file a bond motion in front of the trial judge, and 3 to 5 days from now, it will be heard. The state's burden then is to bring the victim if she wishes to appear. If she doesn't come or the state's unable to secure her presence, your client will still get that hearing because it's not an absolute right.
I completely understand and agree with everything you're saying, but I would add this from my hyper-focused on the accused rights perspective. My client, the fact that the state, through one of its agents or agencies, whether it's the law enforcement officers who are required to give victim notification, or whether it is clerks of courts or staff at the jail who are charged with the duties of Vine, or whether it's the state attorney's office and their victim advocates, the fact that all of them have failed within a 6-day period of time, including since my client was arrested over about 24 hours ago or more, and has been here in the jail to notify the alleged victim, shouldn't deprive my client of the opportunity for consideration at a bond hearing. However, if that is all said respectfully, I don't mean to, I'm just being an advocate for my client.
No, I understand. That's your job. I expect you to do that, counselor.
And as part of that, thank you for that. As part of that advocacy, for example, if we take that to an extreme and say, well, it's been 30 days and we haven't gotten around to letting the victim know, how long is my client supposed to reasonably wait when they've had ample opportunity to give notice and give the opportunity for the victim to be present, or the alleged victim? I need to get used to saying better. So,
right.
What if the court's not comfortable with that argument and exercising your discretion under these circumstances? At a minimum, I would request that this first appearance be rescheduled, perhaps as early as tomorrow, and the burden is on the state to get the notification and have the victim given an opportunity to proceed. And if you feel that that will allow you to exercise your discretion more thoroughly, having heard from the alleged victim, then we're certainly, while not comfortable with that, understanding of that.
All right, well, let me just, I just want to correct one thing that you said, because I want to make sure the record is clear. I don't think the state has had 6 days to notify the victim of this hearing. They wouldn't know he was getting arrested yesterday. So you're correct. At whatever time he got arrested, that's when the state could have and should have then started looking for the victim. But it wouldn't have been 6 days ago when the warrant was issued, because they didn't know when he would be arrested and brought to jail on the warrant. I don't think you intended to say that exactly, but I want to be sure the record's clear, because I don't think they've had 6 days.
I appreciate what you're saying. That is practically true. I am speaking through the agency theory that the state and its agents had knowledge of the proceedings that they could have informed. But I get the practical issue is, I don't know that law enforcement officers,
Right.
At a minimum, he's been here since yesterday.
Well, that's an interesting request, counselor. Let me ask the state.
Your Honor, under the rule, I'm not sure if we're able to reset except for PC purposes, as he has a right to be seen at IA within 24 hours of arrest, which would be the hearing for today. But under the rule that allows us to reset for exigent circumstances, I don't believe, one, this would arise to those circumstances, and two, there's already been a PC finding.
Right, that's interesting. I think you are right about the rule. Because probable cause is already found, it's basically a bond hearing.
Which is part of a first appearance's considerations initially, as to determine a reasonable bond. And there is no rule that I know of precluding the resetting of a first appearances to accomplish the material purposes of a first appearance and give that constitutionally guaranteed effect to a 24-hour, 24-hour review by a court if you're not released on bond. That's the whole point. You're not being released on bond. A court should review that within 24 hours, not only for probable cause, but also for release purposes. And if in every way substantively the facts appear that a bond should be granted, and the only reason that he's not being given a bond is because some either lack of notification, or if notified, the alleged victim has chosen not to appear, then that doesn't seem like appropriate. I would ask that at least I think it's actually bending over backwards reasonable request to say, well, let's at least bring them back and give them a chance to have the alleged victim here.
Except that he's not entitled to bond on this charge. So,
correct. But he is entitled to your discretion in giving a bond.
which I'm not inclined to do.
Under these, okay.
Counselor, reading the affidavit, I'm not inclined to grant your client bond.
I'm sorry, I misunderstood earlier. I thought you said you would be inclined if it wasn't an F1 PBL and the victim weren't present.
I did say that, but because it is a punishable by life offense, I'm not inclined to set bond. I would, however, because my inclination is not to, does not mean I will not listen to all arguments that you have that are reasonable. And if the victim had been notified, it's another hurdle that we would have crossed. So is the state objecting to resetting this for tomorrow?
I just don't know what legal entity allows us to do so, because we usually only reset subject to 3.133 for PC purposes, which ultimately reads, after showing of extraordinary circumstances, it can be moved for 24 hours, not beyond a 48-hour period, solely for PC purposes.
If I may, Your Honor, and if it's worth anything, my over 30 years experience in criminal law as a former prosecutor and as a defense attorney, I have had many first appearances reset, not just for PC purposes, but because of victim notification issues when the state has even requested such. And the court has wanted to hear from the alleged victim before issuing a bond, for many reasons, including appropriate conditions. Therefore, I know of no law or rule precluding the court from resetting, just like we do when, in many circumstances, resetting a first appearance.
All right, here's what I'm going to do. I'm going to reset it for tomorrow. It'll be heard by Judge Bain. I'll be sure to contact him today to explain what we're doing here. Ms. May, can you ensure that every effort is made to notify the victim of the hearing?
Yes, Judge.
I will tell you that in my experience, the entire year that I've been here at the jail, it doesn't matter what time I tell them to bring him back tomorrow, he will be here at 9 a.m. So, is there a time, is that okay with you?
I will be here at 9 a.m.
All right, so we'll just say 9 a.m. Now watch, it doesn't happen tomorrow. All right, so we'll reset it for 9. That gives the state reasonable time to make reasonable efforts to notify the victim. It will be up to Judge Bain's discretion, however. I can't obviously bind him, but I will make sure he understands everything we've discussed here today and allow you to make those arguments to him.
Very well. I appreciate it, and sorry to be the fly in the ointment this afternoon.
No, it's been a day. It's not just you. So thank you, counselor. Thank you for your patience. Thank you, sir. Good luck.
Appreciate it. Thanks.
I know.
You need to talk to him? Yes, if I could, I'll just be out.
Aaliyah Howard.
Okay.
Case number 2021 CF 1553.
Ma'am, you're here charged with shooting or throwing a missile into a dwelling, a structure, or a vehicle, and carrying a concealed firearm. At this time, I'll appoint an attorney to represent you. There is probable cause. Does the state wish to be heard on bond?
Your Honor, she is otherwise entitled to a reasonable bond, so the state would ask that you set that bond. Take into account that she does have, it looks like at least five states worth of history. So state's concerned regarding her likelihood to come back to deal with these charges, as well as the severity of the charges, as there was a firearm involved, as well as a firearm discharged, as well as a video that somewhat depicts this incident and the defendant having a firearm. So state would ask for a reasonable bond, taking all that into account.
Any response, Mr. Brandt?
We just request a reasonable bond on this, Your Honor.
According to her IA sheet, she's been in Orlando for approximately 5 days and intends to go back to Maryland.
I saw that, and I saw extensive out-of-state history. Additionally, the court is concerned with the violence in this case. Ma'am, your bond on count 1 will be $10,000. Count 2 will be $5,000. With special conditions, you can have no contact with any victim or witness in this case. You cannot return to Wood Hollow Apartments for any reason. You can't possess a weapon of any kind, firearm or ammunition. Was this gun collected at the scene, Miss May?
I believe so, Your Honor.
All right.
I took possession of the black 9mm. Yes, Your Honor.
All right, good luck, ma'am.
$21 2021 CF 15554AO.
Sir, you're here charged with threatening a public servant, resisting without violence, and aggravated battery with a motor vehicle. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $1,000 on count 1, $500 on count 2, $5,000 on count 3. With special conditions, you can have no contact with any victim or witness in this case. You can't possess a weapon, firearm, or ammunition. You can't return to this area for any reason. Do you understand?
Yes, ma'am.
All right, good luck.
My name is Nishan Joseph.
Case number 2021 CF 15535AO.
You're here charged with fleeing or attempting to elude law enforcement officers. There is probable cause. I'll appoint an attorney to represent you. Your bond will be $15,000. All right, good luck, sir.
I'm sorry. Wallace Lane.
Case number 2021 CF 15521AO.
Sir, you're here because a warrant was issued for your arrest for failing to report.
Yes, ma'am. I did report, but I just reported late because I was still at the house. I just wasn't inside the house. I was parked over because I was homeless and looking for a place to park my car.
All right. A warrant was issued for your arrest, so another judge has already found probable cause. I'll appoint an attorney to represent you, and I'll not raise that bond. So your bond is $5,000. Mr. Lane, you have to comply with your sex offender reporting requirements. You understand?
Yes, ma'am. I've been on it 30 years. I haven't had an issue. I have had an issue for 22 years, and that was an issue with like a lie detector test. That's the only thing. And I was at the house at night, 2 nights before I reported. And Saturday and Sunday, I couldn't report. And then I went back and reported.
You don't have to keep talking. She
Oh.
just wants you to report.
Oh.
Okay?
Oh.
And then that's your bond on it.
Sir,
Ma'am.
you may have some defenses to this charge,
Yes,
but you
ma'am.
can't raise them today.
I'm sorry, ma'am.
It's okay.
I don't know. I've never been in trouble. I haven't been in trouble.
It's okay, I understand, and I'm looking at your record, and
Yes, I
it doesn't look like you have a lot of problems since this conviction.
Can I ask for a bond reduction now, or do I have to come back?
You can, I'm not inclined to do that. I was actually going to raise your bond to $15,000, but as soon as you came in, you explained to the court about the violation, and so I did not raise it.
Okay.
He is an Army veteran, Your Honor.
I see that. Sir, did you serve in Vietnam?
Yes, ma'am.
Thank you for your service.
Thank you.
All right, I'm going to cut the bond in half, sir. Your bond is $2,500, but you need to stay in touch with your attorney, because if you want it even lower than that, you're going to have to go in front of the trial judge.
Okay, thank you. Thank
Yes,
you,
sir. Good luck.
Thank you.
Said 2,500.
I did.
Your Honor, Eric Lewis bonded.
Good morning. My name is Frankie Lopez.
Case number 2018 CF 1791080.
Thank you. You're here because a capias was issued for your arrest for failing to appear for court on a charge of possession of an unauthorized driver's license. At this time, there's no bond authorized, and I'll appoint an attorney to represent you. Good luck, sir.
Thank you.
Lasenia Martinez.
Case number 2021 CF 1441480.
Ma'am, you're here because a capias was issued charging you with, and then an information was filed charging you with criminal use of personal identification information of 20 or more persons and a scheme to defraud with greater than $50,000. The state's already filed a charging affidavit in this case. At this time, I'm setting your bond at $15,000 on count 1, $5,000 on count 2. With special conditions, you can have no contact with any victim, witness, or co-defendant in this case. And let me ask about these detainers.
Here are the conditions on an order that was sent. One moment.
From what court?
Also, in this case, she has a whole paragraph of conditions.
Oh, that's where this is. That's what I'm looking for.
Okay.
They just found it. Okay.
I was looking for it too.
Ah, thank you. Right. So, hold on one moment. The following conditions apply. You must demonstrate that the source of funds used to post bail or any proposed collateral or bond premium are not linked to or derived from the crimes alleged to have been committed in this matter or from any other criminal or illicit activities. You must remain within the state of Florida and within your county of residence, except when attending court proceedings or meeting with your attorney. You must surrender your passport. Ma'am, where is your passport?
I don't have one. I haven't had one in the last 4 years. Since 2016, I haven't had my passport.
Where is it?
I don't. Someone had broken into our car and it was taken. And as of 2016, I haven't had it.
Your Honor, trial division will probably have to file a motion to get that stricken.
Yeah, Mr. Brantz, I think you're gonna have to make a note for your colleagues because I'm not going to change that condition. So she'll not be able to bond out until she can surrender a passport.
How do I prove that I don't have it at all in my possession, or I don't have one at all?
Your attorney is gonna have to file a motion in front of the trial judge and demonstrate that to that judge's satisfaction before you'll be allowed to bond out. So the order is that she has to surrender her passport before she's released.
on?
Yes.
Also marked respondent.
Good afternoon, ma'am. My name is Willie Patterson Jr.
Good afternoon, sir. You're here in 21 CF 15563, charged with possession of methamphetamine, cocaine, and drug paraphernalia. I'm going to appoint an attorney to represent you. Mr. Brantz, did you wish to be heard?
No argument at this time, Your Honor.
There is probable cause. Your bond is $1,000 on count 1, $500 on count 2, and $100 on count 3. With special conditions, you can have no contact with any co-defendant or drug dealer in this case. Co-defendant in the case or any drug dealers. You can't possess or consume any controlled substance without a valid prescription. Good luck, sir.
Your Honor, Javar Reed, VP refused.
Case number 2021 CF 14482AO.
It's a warrant. I'll find his refusal a willing waiver of his appearance. Mr. Brantz, I'll appoint your office.
Thank you.
Bond is $1,000. No return to the scene, no contact with victim or witness.
Rondo Resto Garcia also refused.
Case number 2021 CF 4113AO.
It's a capias. I'll find his refusal a willing waiver of his appearance today and appoint your office, Mr. Brantz. Bond is $2,000.
Manuel Rivera, Your Honor.
Case number 2021 CF 15523AO.
You're here charged with possession of fentanyl. A warrant was issued for your arrest, so another judge has already found probable cause. Your bond is $2,500. I'll appoint an attorney to represent you. You can't possess or consume any controlled substance or have contact with any known drug dealers. Good luck, sir.
Tracy Robinson.
Case number 2021 CF 15574AO.
I don't have that case.
Do you want the?
Good afternoon. You're here charged with prostitution, third or subsequent violation. There is probable. Let me appoint an attorney to represent you.
Can be heard as to probable cause.
Yes.
I believe we had an instance of this a while ago about there needs to be something in the arrest affidavit that suggests that there was a conviction for subsequent violations or precedent violations. I believe the arrest affidavit mentions arrest, but not conviction. So I don't know if there's enough probable cause to charge prostitution third subsequent.
What says the state?
One second, Your Honor, I'm checking the statute.
I think it was brought up by this court. I just remember it. Had it in my back pocket.
Generally, the statutes say like two prior or implying that there is a conviction. I don't know if third subsequent violation holds a different meaning about it having to be a conviction.
So it says any person who is charged with a third or subsequent violation of this section. Charged with a third or subsequent violation. It does not say conviction.
Even if that were so, Your Honor, I don't believe the arrest affidavit, they mention arrest. I don't know if they mentioned, I don't believe they mentioned that charges were filed, informations or indictments.
I believe an arrest would fall under a violation, Your Honor.
The statute says charges.
Well, an officer charges as well. Depends on your definition of the charges.
When I hear charge, I think charging document.
Well,
Because like, for instance, in the DUI statute or petty theft, does it not say second conviction, third conviction?
yes, Your Honor.
Battery as well, Your Honor.
Yes.
This statute doesn't say that. It says third or subsequent violation of this subsection other than paragraph 2F. And 2F is oh, right. A person who violates paragraph 2F, that's what this is, commits a felony of the third degree for a second violation.
Is a violation a conviction? We don't necessarily, even if I'm arrested for a crime, that doesn't necessarily mean I violate a statute. I have to be found guilty, I believe.
Do you have any case law, counselor?
No, I'm just using the literal reading of the statute and perhaps my own dictionary definitions of the words used in the statute.
I think the court's required to use a reasonable definition of the words in the statute unless there's a particular definition, which there are several definitions in this statute, actually. It defines prostitution, lewdness, assignation, sexual activity. It doesn't define violation. But it says a person who violates paragraph 2F, which is to solicit, induce, entice, or procure another to commit prostitution, lewdness, or assignation. I think a reasonable reading of the statute is a violation is not a conviction.
Well, to counter that, Your Honor, would an arrest be a violation?
I think it is.
But how do we conclude that something has been violated? Even though there's probable cause, we argue all the time that we're not necessarily saying you're guilty, we're just saying that there's probable cause enough to arrest you. I don't think we use the word violate in our everyday vernacular when we talk about it.
Right, I don't think we do either, but because it's used in the statute, I think the court has to look at a reasonable reading of that word.
Understood, Your Honor.
Unless you find case law that says otherwise.
I will look
Okay.
for future reference.
I was looking to try to find a definition, and I cannot find one, at least not quickly. However, reading further down in the statute, which does not apply to us, however, reading further down, it does use language of a person convicted of a second or subsequent violation. So there does seem to be a clear delineation between convicted and violation. That's in 5B. In addition to any other penalty imposed, the court shall order a person convicted of a violation to X. Or 5C shall sentence a person convicted of a second or subsequent violation to the following. So there does seem to be a delineation between conviction and violation.
All right, for purposes of probable cause today, I find there's probable cause here. Your bond is $1,000. Are there any conditions the state would request?
Your Honor, state would just ask for no return to the mapping zone 42, which is Miller in Nashville.
All right, you can't return there. Do you understand? So I show that he's out on bond for the exact same charge.
Check, Your Honor.
So, Mr. Brantz, I'm inclined to revoke his bond unless you can give me a reason not to.
Just a moment to confer, Your Honor.
Yes.
Your Honor, that case, the arrest was November 12th, so a little under a month ago. We have not filed on it yet. We also haven't hit the 33rd yet. And he bonded. But it was approximately a little under a month ago.
Mr. Brantz, I'll take no action on that case.
Thank you, Your Honor.
Yes, sir. Good luck.
Thank you, Your Honor.
Ivan Rodriguez.
Case number 2021 CF 15575AO.
Sir, you're here charged with possession of methamphetamine. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Good luck, sir.
Reno Rogers.
Case number 2021 CF 15564AO.
Sir, you're here charged with possession of cocaine with a weapon. I'm going to appoint an attorney to represent you. Did you have an argument?
Not as to probable cause, but as to bond conditions.
I agree. There is probable cause. Go ahead with your bond conditions.
He was very cooperative with the officer when stopped. He did notify the officer of the weapon, so I would have you consider that in setting bond. We also have little to no criminal history.
Anything from the state?
Your Honor, state was going to make the same arguments. It looks like he has no criminal history. He does qualify for pretrial release, so state has no objection to you putting him on pretrial release or pretrial release with bond. He was incredibly cooperative with law enforcement, answering questions post Miranda, so state has no objection to a lower bond than what is currently set.
Did you ask for pretrial release, Mr. Brantz?
I did not, but if you're inclined to set straight PTR, I would support that decision.
At this time, sir, I'm going to place you on pretrial release with special conditions. You can't possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers. I'm hesitant to order no weapons. He has a permit. Do we know that he actually has one?
Not that I've confirmed, Your Honor. However, given that he is charged with a felony at this time, he's not allowed to have a felony or have a firearm regardless.
Right.
So they would ask that you still said that.
So I will order you can't possess a weapon, firearm, or ammunition at this time. I understand you have a concealed carry permit. You're going to have to talk to your attorney about what you're going to be able to do with that in the future. Yes.
Okay.
Torres.
Case number 2021 CF 14419AO.
Sir, you're here because a warrant was issued for your arrest, charging you with aggravated assault with a firearm and possession of a firearm by a convicted felon. Another judge has already found probable cause. I'm going to appoint an attorney to represent you in the case. Does either side wish to be heard on bond?
Just a reasonable bond from the defense, Your Honor.
Anything from the state?
Your Honor, yes, he is otherwise entitled to a reasonable bond. State's main concern is he does have a lot of Florida history. However, most of it does seem drug-related. And at least 6 prior VOPs, so state's concerned regarding his willingness to comply with court orders. It also looks like he has several out-of-county holds. So state's concerned about his willingness to come back and take care of these charges, given that they are violent in nature. I believe it is alleged that he did point a shotgun at the 6-month pregnant woman's stomach as well as head. And I believe there was an independent witness who did also testify to that. So he is otherwise entitled to a reasonable bond, so we just have you take that into account.
Thank you. The court is also concerned with those things. I show 5 prior failures to appear. Sir, you currently have a holdout of Volusia County. I show that he's a violent felony offender of special concern. At this time, sir, your bond on count 1 is $25,000. Count 2 is $4,000. With special conditions, you can have no contact with the victims or any witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You can't return to the scene for any reason. You can't be within 1,000 feet of the victim's residence or place of employment. Are there any other conditions the state would request?
No, Your Honor.
I'm sorry, what was the bond amount on count 2?
$4,000.
Thank you.
I stayed that one.
Your Honor, Jeremy Vasquez bonded. Tatiana Vera, she refused.
Case number 2021 CF 15538 AO.
And
Oh, she got it. And 2021 MM 8629 AO.
I'll find her refusal a willing waiver of her appearance today. I'll appoint your office in both cases, Mr. Brantz. Her bond on the possession of cocaine is $1,000. No contact with any known drug dealers, cannot possess or consume any controlled substance without a valid prescription. In the trespass, it's $500, cannot return, no contact with any victim or witness. At this time, I'm revoking her out on bond case.
You say you found PC and I didn't hear it.
There is, I did find probable cause, sorry. I might not have said that. There is in both cases. Please tell me your name.
James Washington.
Case number 2021 CF 7559 AO.
Mr. Washington, you're here because a capias was issued for your arrest for failing to appear for court on a charge of possession of cocaine. The judge authorized a $500 bond. I'm appointing an attorney to represent you. You want to call your attorney right away, okay?
Yes, ma'am. I wanted, like, I talked to him, explain, it's like, I was on bond since July, and the bondsman that I had, one of the assistants told me the charges had been like no action because I had came later on in July, I had a paraphernalia charge, and that got no action. So I'm assuming that I had no charges. I didn't never get a court date, so if I had a court date that I would known of, I would have came to court, because I don't like to be stuck in jail and stuff, having to have to get out and start out with nothing and stuff, so.
I believe you, sir. Unfortunately, because it's a capias, by law, I can't change it. You're gonna have to talk to Judge Bleckman. He's the judge who's hearing your case.
Yes.
So you do have a bond. If you're able to post it, you can bond out. But if not, you have to make the argument to him. I can't change his capias.
Mm-hmm.
You understand?
Give us a call, we'll try to get you in front of Judge Blackman right away, okay?
Call the number on that green piece of paper.
All right, ma'am.
Yes, sir. Good luck.
Marquette Willis.
Case number 2021 CF 15098 AO.
A warrant was issued for your arrest, charging you with 2 counts of sexual act with a 16 or 17-year-old child, 1 count of lewd or lascivious battery. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Your Honor, he is charged with all F2s, so he is entitled to a bond. I do believe he has some out-of-state arrest history. I'm not sure of anything else besides that. However, given the allegations within the warrant, it did seem like Mr. Lamonte Mr. Willis, had a close relationship with this family and the children that were residing within the household. So stay with that, so you take all that into account, as well as the allegations that are within this affidavit or warrant, and into the fact that they are F2s and he does have some out-of-state history. The state's partially concerned about his willingness to come back and deal with these charges at a later time.
All right, anything from the defense?
Your Honor, Mr. Willis is entitled to bond on these charges, as well as his limited criminal history in Florida. The out-of-state is, I believe, traffic-related, driving while license suspended, no moped license, and those were arrests, no out-of-state convictions. He has been employed full-time as well for 7 months. I would just have you set a reasonable bond under those circumstances.
I reviewed the affidavit for this warrant. I find the allegations incredibly disturbing. The court is concerned about, as the state said, the close relationship between your client and these victims. Sir, you keep raising your hand. I want to make sure you understand. You can say anything you want, but everything you say is being recorded and can be used against you later.
Your Honor, I think a no contact order with the alleged victims and witnesses, and perhaps even other family members that live in the house, would be appropriate. Mr. Willis does have a girlfriend who is going to let him live there, so he would be a separate residence as well. May I inquire about whether he needs
About what?
a one-time return? May I inquire if he has anything at the
Yeah, ask him about that.
anything at the house?
Your Honor, I believe the defendant was the live-in boyfriend of Shania, who I believe also lived in the house. So I don't know if the defendant and Shania have both moved out. However, I just wanted to make sure that was clear.
Also, Mr. Willis doesn't have anything at that location, so he wouldn't need to go back there anyway.
All right. But I also read in the affidavit that his girlfriend lives in the home and is a family member of all of these victims.
That's an ex-girlfriend, Your Honor. This new girlfriend that he would be staying with is a different individual. So a no contact order with no return. There's no need. You can order a separate residence as well, but there would be no need for a one-time return, as there's nothing there of Mr. Willis's possessions.
All right, thank you. At this time, sir, your bond on count 1 is $150,000. Your bond on count 2 is $150,000. Your bond on count 3 is $150,000. You can have no contact with any victim or witness in this case. Do you understand what no contact means?
Yes.
That includes Shania. You can have no contact with her. You can have no contact whatsoever with any minor child under the age of 18. Do you understand that? You can't return to this residence for any reason or be within 1,000 feet of any of the victim's residences, place of employment, or school. Do you understand that? You can't possess or consume any alcoholic beverages. You'll be subject to random alcohol screens. You can't possess or consume any controlled substance without a valid prescription. You'll be subject to random drug screens. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck. Actually, I'm going to amend that. No contact with any victim, witness, or any family member of any victim or witness. Okay, good. Thank you.
Your Honor, Cameo Bannister is mental health.
Case number 2021 MM 864780.
I'll appoint your office, Mr. Brantz.
We'll waive the appearance, Your Honor.
There is probable cause. His bond is $500 on count 1, $500 on count 2. No contact with any victim or witness. No weapons, firearms, or ammunition. Cannot return to the scene.
Forgot that.
And that was medical?
Mental health.
Mental, thank you.
What'd you say? That's it. I am done.
Okay. We forgot. Did you see?
All right. I want to return to Mr. Willis's case really quickly. Did you all hear me say he can't possess any weapons, firearms, or ammunition?
Why'd you say that?
No, Your Honor.
All right, can we bring him back in? I'm sorry, I thought I ordered that.
I have it to the side.
Thank you, I appreciate that.
And we're done with the other one, right?
Yes. Do you want to do this case while we wait?
That's fine, Your Honor.
We can hear his case while we wait.
Your name is- Sorry.
Please tell me your name.
David Marquette Walter.
Case number 2021 MM 863080.
Sir, you're here charged with battery. I'm going to appoint an attorney to represent you. Did you wish to be heard?
Thank you, Your Honor. No, there was no offer from the state, so we would just have you set bond on the battery.
There is probable cause here. Sir, your bond is $500. You can have no contact with the victim. You can't possess any weapons, firearms, or ammunition. You can't return to the scene.
Yeah, for a year.
All right, good luck, sir.
Your Honor, he is on Social Security income, and if you are inclined to lower the bond to $100, they
Your Honor,
is able to bond out.
state would object. He does have a prior conviction for violating a DV injunction as well as a prior ag bat. And he's currently charged with a battery.
I saw that in his history, which is what concerns me, Mr. Brantz.
Yes, sir.
And the violation of a domestic violence injunction is it's violating a court order.
Not gonna lower it. Give us a call, we can try to lower it downtown. Give us a call, we'll try to lower the bond when you get in front of the trial judge.
Call your attorney, sir. They can file a motion to reduce your bond.
Okay? Thank you, Your Honor.
Yes, sir. Mr. Willis? I'm sorry, we had to call you back in here because I thought I ordered something and the clerk pointed out I didn't. This is 21 CF 15098. You are also not allowed to possess any weapons of any kind, firearms, or ammunition. Do you understand? All right, good luck. Thank you.
I need
Do you need a break?
I need a strong cup of coffee after this.
He's just losing his mind. It's okay. I'm cool.
I've had 2 chocolate bars.
Case number 2021 MM 8654AO.
Ma'am, you're here charged with prostitution. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can't return to, can you give me the area, Miss May?
It's Zone 44, which is at August Lane and Orange Blossom Trail.
All right, you can't go back there, ma'am.
Was it just the mapping zone?
Yes.
Keisha Holt. Case number 2021 MM 8655AO.
Ma'am, you're here charged with prostitution. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You cannot return to the area located at
Zone 44, August Lane and Orange Blossom Trail.
You can't go back there, ma'am. You understand?
Yes, ma'am.
Gregory Lane.
Case number 2021 MM 294AE.
Your Honor, this was a trespass, and I did have an offer from the state of an adjudication of guilt, credit time served, and no return. I did have a chance to speak with Mr. Lane about that offer, as well as handed a plea form to review. We went over the rights to be waived, as well as probationary and citizenship issues. I believe Mr. Lane wishes to enter a no contest plea today.
Raise your right hand, sir.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yeah.
All right, sir. There is probable cause for this trespass charge. You had the opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yeah.
Do you have any questions for me about them?
No.
All right, sir, at this time, how do you wish to plead to the charge of trespass and occupied structure or conveyance?
Understand?
Just a moment, Your Honor. No comments, Your Honor.
All right, sir, how do you wish to plead to the charge of trespass and occupied structure?
No contact.
I'll accept your plea, sir. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. You cannot return to the Family Dollar at 111 East Kennedy Boulevard. Do you know where that is?
Yeah.
All right. Good luck, sir. You have 30 days to appeal in writing.
Can you repeat the amount of court costs, Your Honor?
It's about $300.
You have a year to pay him. Was it a year, Your Honor? I'm sorry.
I did give him a year.
Pay the clerk. Okay. Yeah, you will. We have it.
My name is Sarah T. Lynch.
Case number 2021 MM 812AW.
Ma'am, you're here charged with trespass. There is probable cause.
An offer was conveyed of a withhold credit time served and no return to the fountain at 78 West Plant Street. However, I also informed defense that she may qualify for pretrial PTD at a later time.
And I did speak with Ms. Lynch about possible pretrial diversion and work with our office to perhaps resolve this in a different, down a different route. So I would just have you set, if you aren't inclined to release your ROR, a very low monetary bond as to the charge.
I see that she has no criminal history.
I believe that's correct, Your Honor.
State has no objection, Your Honor.
All right, ma'am, I'm going to release you on your own recognizance, so you don't have to post a monetary bond, but you understand that you cannot go back to that fountain.
Yes.
All right, good luck, ma'am. Stay in touch with your attorney.
Ricky Powell.
Case number 2021 MM 8635AO.
Sir, you're charged with retail petty theft. There is probable cause.
Your Honor, there is no offer conveyed due to it being enhanceable.
Sir, your bond is $500. You can't return to the Publix located at 400 East Central Boulevard or have contact with any witness in this case. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Andrea Sharber.
Case number 2021 MM 8653AO.
Ma'am, you're here charged with resisting an officer without violence and possession of drug paraphernalia. There is probable cause.
There was an offer from the state, Your Honor, an adjudication of guilt credit time served. I did have a chance to speak with Ms. Sharber about that offer and a plea form to review, as well as any repercussions from entering a plea, citizenship, and probationary issues. I believe Ms. Sharber wishes to enter a no contest plea.
I don't know that I'm inclined to accept that. I see that her most recent conviction was 2 days ago to a charge of battery on a law enforcement officer. This charge is resisting an officer without violence.
Just a moment to confer, Your Honor.
Can the state tell me what was the sentence in the battery on a law enforcement officer? I mean, it shows it was 2 days ago.
I see a resisting with from 7/16/2021.
Oh, maybe it wasn't here.
I don't see it.
It was here.
It was here.
On case number. 2021 CF 12862. She was arrested on and on September the 27th. She was released, time served on December the 6th, 2021.
Your Honor, if you're not inclined to accept the plea, we would just have you set a low bond here. If you are inclined to set ROR, I spoke with Ms. Sharber. She does have some housing issues. She doesn't receive mail, but she does have a friend that allows her to use the phone, and I have conferred with her that she keep in touch with our office once a week using that phone. That way we can inform her of any court dates so that she can appear. If you aren't inclined to set ROR on this charge, I would just have you set a low monetary bond as she is.
Your Honor, state would object to ROR. She does have a recent failure to appear a few months ago. And the allegations in the Bat Leo resisting without that she just pled to was almost the same exact facts. It occurred September 27, 2021. Law enforcement responded to a suspicious person. They advised that a white female was aggressively panhandling in the median and hit their car. They did not give her money. Law enforcement arrived. Defendant pulled away, punched her in the face, scratched law enforcement's cheek. Eventually, they were able to secure the defendant, which is similar to the facts that we have in this case regarding calls about a suspect in the street aggressively panhandling and then resisting.
Your Honor, may counsel approach?
Yes. All right, ma'am, at this time, your bond is $500 on count 1, $100 on count 2. With special conditions, you can't possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers. You can't possess a weapon of any kind, firearm, or ammunition. Good luck, ma'am.
You'll be my attorney still.
We'll have an attorney with us, yeah.
Linda Gibson.
Case number 2021 MO1445 AO.
Ms. Gibson, you're here charged with camping on private property. There is probable cause, and I'm sure you saw me smile just a minute ago. I'm smiling because we have the same last name. But just for the record, we're not related, right? It just happens to be a coincidence. Was there an offer in this case?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold credit time served.
Your Honor, I did go over that offer with Ms. Belinda Gibson, and we went over the plea form for her to review the rights to be waived as well as any issues with citizenship and probation. I believe she wishes to resolve that with a no contest plea. However, for the record, Ms. Gibson informed me that she had been allowed to stay on that property for a while, and it was just recently that I believe they rescinded that that allowance, but she would still like to resolve that with a no contest plea.
Ms. Gibson, it sounds like you think you may have a defense to the charge. If you enter a plea of guilty or no contest today, I'll sentence you today. You won't have the opportunity to raise that defense. Do you understand that?
Yes, ma'am.
And that's what you want to do?
Yes, ma'am.
All right. Raise your right hand, please.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so you had an opportunity, you can put your hand down. An opportunity to discuss with an attorney the rights you'll be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
And again, if you have a defense to this charge, you could raise it at a later time.
Yes, ma'am.
And maybe your attorney can convince the state to drop the charge. You understand that?
Yes, ma'am.
But if you enter a plea of guilty or no contest today, You won't have that opportunity. All right, at this time, how do you wish to plead to the charge of camping on private property?
No contest.
I'll accept your plea, ma'am. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for
2 days.
2 days in custody. Ma'am, I have to order that you pay court costs. I'm going to reduce that to a lien. Good luck, ma'am. You have 30 days to appeal in writing.
You said no return, or you down?
James Christmas.
Case number 2004 CT 1946 AW.
Sir, you're here because a capias was issued for your arrest for failing to appear for arraignment on a charge of violating DUI probation. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck, sir. That's VOP. Hold on a second. Mr. Christmas.
Mr. Christmas.
Hold on one second.
Disposition.
I don't think it's a VOP. I think it's just a failure to appear. I'm sorry, it is not a violation of probation. It's just a failure to appear. It looks like maybe for trial.
I have that it's pled. That he pled no contest 42505.
Wait. Oh, so it is a VOP.
No,
Hold
I
on.
pled guilty to the violation.
Yeah.
I think I'm about 90 days in on this. I had a bond in Bonnefay, Florida. I thought it was a purge because it was from 2004. The case was so, but I didn't get the court date. I didn't realize I had a court date. I would have showed up, but I didn't realize the $1,000 bond was a purge. Being 18 years old, I didn't realize I had probation. I violated it, and then they put a bond on me. Then they put me a bond for $1,000 purge. I paid it, but I didn't realize it. I really thought that it was they was paying a purge on it because of the case being so old. That was so long ago.
So it is a VOP?
Yes, Your Honor.
All right, do you want to enter a denial, Mr. Brantz?
Yes, Your Honor, we'll enter denial on that.
And it's going to be Division 83 VOP status, January 10th at 1:30 p.m. in 6C.
So that's your next scheduled court date, but if you call the number on that piece of paper, see if you can get to talk to your attorney sooner. I mean, I understand what you're saying, and this is a really old case.
Yeah, and there's no way to play out in a time.
There's not. I can't do it, and I can't change the capias either.
January to
Give us a call, maybe. Know the judge will. All right.
Won't be here, right?
Want us to.
Samuel Hamilton.
Case number 2021 CT 8016 Oh. Okay. Case number 2021 CT 801780. Case number 2021 CT 801880. Case number 2021 CT 801980.
Sir, you're here charged with attaching a tag unassigned to a vehicle, no motor vehicle registration, DUI with property damage or personal injury, and leaving the scene of a crash with property damage. I'm going to appoint an attorney to represent you. Mr. Brantz, did you wish to be heard?
Our only request is to treat 3 of the charges as subsidiary.
All right, there is probable cause. What says the state?
Your Honor, state has no objection.
On the DUI, sir, your bond is $1,000. Leaving the scene of a crash with property damage. It'll be $100, no motor vehicle registration and attaching a tag, each $100. Sir, you can't possess or consume alcoholic beverages or any controlled substance.
Yes, ma'am.
Without a valid prescription.
Yes,
I see that you're shaking.
I'm just having an anxiety attack.
Okay. Can you breathe? Will it help if you sit down?
It will, yes.
Can we get him a chair?
Slow breaths. Got one, I got one.
Medication for 4 days.
All right. I just want you to breathe.
Your Honor, may I approach?
Yes.
Counsel. You don't have to.
Mr. Hamilton, do you feel better outside the courtroom or here in the courtroom?
Outside, but can we just get this over with?
Yes. All right, Mr. Hamilton, can you be calm enough to listen to what I'm saying right now? Okay, you said you want to get it over with. I'm going to try to do that. So I found probable cause in these cases, but I gave you bond. But you can't drink alcohol. You can't take any drugs unless you're prescribed them. You told me you have some prescriptions. You need to take those as prescribed, okay?
Don't breathe, man. Don't hold your breath.
Yeah, don't hold your breath. Keep breathing. You can't have contact with any victim or witness in this case. And at this time, I'll take no action on the out on bond case. So I'm not revoking your bond. So you have bonds in all your cases. You understand? Sir, you have an attorney. I want you to call your attorney, okay? Yes. All right, it's okay. Just breathe, sir. You're done.
Deep breath.
You can leave. Thank you. Mr. Brantz, did you make some notes about that?
I did, Your Honor.
Okay.
Thank you.
I assumed, but
Sorry? Sorry.
I assumed you would, but I just want to remind you in case. You want to get your client's name?
Hubbard. Case number 2021 CT 802280 and 2021 CT 802180.
I have a different case number.
You said Herbert?
Hubbard. 8022 and 8024.
Yes. I'm sorry. I was trying to read it from here.
All right. Your here charge was leaving the scene of a crash with property damage and false reports to police officers. I'm going to appoint an attorney to represent you. There is probable cause. One moment. All right, I'll stay the bonds as listed. It's $1,000 on the hit and run and $500 on the false report to law enforcement. With special conditions, you can have no contact with any victim or witness in this case. You can't drive without a valid Florida license. Do you understand? Good luck. That's all I have.
Rachel.
This was the.
Risa brought you in.
Did you see those emails? Can I inform Ms. May of what, is this,
Yeah.
Yes.
Unless a party is making a motion.
He does, so he is able to be released ROR as to the failure to appear.
I don't know what you're talking about. You want to call the case and let's, do you have a motion or something?
Let me confirm his name. Your Honor, can case, I had it for a second. 21 CT 7113 AO. We have a moment to confer with state.
Yes. You know what? Can you do it up here? Can I ask you a question?
I had no idea what was going on.
We're going back on the record briefly, just because I don't think the court has jurisdiction in this case.
May I have a moment to confer? Just
Yes.
before we determine. Could you at least kind of explain why we're having these discussions? It's not about a defense to the failure to appear. It's more so about what the court can hear today.
No, that's right. So what's happening here is it looks like there was a capias issued by another judge for your arrest, authorizing that you be released on your own recognizance. That happened. That's the capias that would give me jurisdiction to hear your case. But because you were released on your own recognizance on that case, I don't have jurisdiction over any cases of yours now.
I never got released from jail without no money and nothing like that.
I can't hear him.
He said when you said he was released ROR, he never left the jail.
Before.
Right, but effectively you were. Because the jail has an administrative policy that's holding you. That's why they're holding you. I didn't order them to hold you. But I also can't order them not to hold you because I don't have jurisdiction to do that right now.
What jail is holding me? That's what I want to know.
Because you have 2 cases for which you were out on bond when you were arrested for a new law violation. So honestly, I don't know the legal mechanism of that either. Do you, Ms. May?
No, Your Honor.
Before I came here, they told me everything will be good. Like, it's RR, I'll get released.
Right. It is on that one case. But because there are the other 2 cases for which you were out on bond, the jail is holding you.
So what are those 2 other cases? That's what I want to know.
Do you know what those are, Mr. Brantz?
Yes. That's what I know. I finished my...
You from the jail because not allowed. Yeah. I know. I just don't understand. I mean, now I'm getting confused, I guess, because if the jail's holding him, what authority does the jail have to hold him if the judge can order the jail to hold someone? There's got to be some greater authority. What?
Any inmate or anyone who comes in on a case, regardless if it's already ROR, PTR, whatever, if they have any open cases, they're out on bond or anything, we have to hold them in order to see if the judge want to take action. Regardless if whatever case, warrant, court order says that release them back ROR, PTR, they have open cases. The jail, our admin order.
Isn't it via admin?
The jail's admin order, not pretrial admin order. The jail.
And my second question is, how can it be resolved tomorrow? How will you have, if you don't have jurisdiction today, how will the court have jurisdiction tomorrow to take any action on
Because
his
we
release?
unprocessed our ROR, which took him off the docket in the first place.
Okay.
So he'll be back on the docket to be IA'd on the FTA warrant tomorrow. Then Judge Bain's going to address the out on bond cases as per usual. Anybody who comes in on.
Okay.
The warrant for his arrest will become active again, and the court will have then jurisdiction over that warrant, that capias.
Is it safe to say that 9 a.m. tomorrow, you'll see the judge again, and then that ROR can take effect?
At some time I mean, it's at 9 o'clock hearing time, but you know how that is. Today we had 100 inmates, so I'm not going to say it'll be at 9 o'clock. He might be at 9:15 or 9:35 or.
Will he be a move up? Do we know?
I don't know the answer to that.
Probably be in traffic, so probably second session. Where he was before.
No, I'm looking it up.
I guess there would be.
Don't do that.
Can the attorneys approach? Yes. All right, so we're going to bring back all of these cases tomorrow to be heard by Judge Bain when the court has jurisdiction over the matters. Yes, that case will be heard by Judge Bain tomorrow. Court is adjourned.